August 21st, 2012. I'll bring this meeting of the Salina City Planning Commission to order. The first item on our agenda today is approval of the summary minutes from August 7th. Are there questions, comments, or a motion to approve?
You make a motion to approve the minutes.
Is there a second?
Second.
All those in favor say aye.
Aye.
The minutes are approved. Our agenda items begin with application CU03-2B, but because of a matter of time, and this will probably be a lengthy meeting tonight, I know that there are at least one person who can't be here for the public commentary on item number 4, Kansas Wesleyan University. So I want to open the public session on number 4, application CU12-6 and application Z12-7 and the following item, CU12-6, for any public comment for those that won't be able to stay for those matters on the agenda. I'm aware that Father Kerry Ninemeyer has an interest in this issue, and he has Mass at 5:15. So if he would like to come up and give his remarks, we'll have them into the record now.
First of all, thank you very much for your consideration. My understanding is what we're doing is considering whether to have advertising on the sign across the street from the property of St. Mary's Church and St. Mary's Grade School, and it would be located on Kansas Wesleyan property, and we have no trouble with that, for the record. And we have talked with them, and we think we're in a really good relationship with Kansas Wesleyan, working back and forth on different items. And we have talked about it, and I kidded them about some advertisements that we probably don't want to see up there, but they're in agreement with that as well, and so we really have no trouble with that.
Thank you for letting us get you on the record. Any questions for Father?
Thank you very much.
You're welcome.
We'll just make sure that public input gets incorporated into the public input for items 3 and 4 at that time.
Is there anyone else on those matters that think that their time is constrained that would want to speak to items 3 and 4 at this time? There being none, we'll start on with our agenda on item number 2, application CU03-2B, filed by Salina Regional Health Center, a conditional use permit.
Mr. Chairman, I'm going to turn it over to the City Attorney, Mr. Bankston, and he's going to update you on our situation as far as your available legal counsel.
Mr. Welsh.
Mr. Chairman, I'm going to excuse myself due to a conflict of interest.
Mr. Chairman and Commissioners, I appreciate the opportunity to explain that we do have a circumstance where our law firm, Clark Mines Linville, serves as general counsel to the City of Salina and to Salina Regional Health Center. As a consequence, in order to assist you in your deliberations, as was the case with the City Commission's deliberations on this matter, we've enlisted the assistance of Todd Luckman. Todd is seated here to my right, and I wanted to introduce you to him. Todd is certainly well recognized in this area of the law, and I know was of considerable assistance to the City Commission, and we asked him to come over this afternoon in the event that you would need his involvement in your deliberations on this matter this afternoon, whether that be in your open session or, as you know, you are certainly, if necessary or helpful, able to address this matter in a closed session as well. But primary point was to introduce Mr. Luckman and to assure you that he is here to be of any service he can be, and we hope you make good use of his trip over from Topeka. So, thank you.
Thank you. Staff want to update us on this issue?
Yeah, I will update you on the status of what has occurred. As you recall, the Planning Commission took action on this on April 17th, and what occurred at that meeting was a motion to approve the conditional use permit as amended, and that motion failed by a 2-to-5 vote. That failure to approve was tantamount to a denial, and the Salina Regional Health Center filed an appeal of that decision within the 14-day period after that hearing. Subsequent to that, the City Commission acknowledged receipt of that appeal, sent the item back to you to better articulate your reasons and findings for that, and those are, I would bring your attention to page 8, where that motion by Mr. Brooks and the findings were made. That was approved by a 5-to-2 vote, and that recommendation or action to deny the request went to the City Commission. They conducted a public hearing on the appeal on May 21st, 2012. And at that hearing, there was quite a bit of detailed information, particularly appraisal information, and particularly information about the services and the operations of Viridian Behavioral Health, which was not presented to the Planning Commission. And the City Commission was also curious whether there were additional conditions or limitations that might be imposed that weren't considered previously that could make the facility more compatible with the surrounding neighborhood. Some of the things that they threw out were limits on hours of operation, limiting it to outpatient services only, making use of the facility subject to the floor plan in addition to the site plan, and further clarifying that approval of the use for the clinic was based on the hospital ownership and wouldn't be transferable to another non-hospital entity. And so this referral back was based on advice that they received from Mr. Luckman, their legal counsel, and as Mr. Bankston indicated, he is available today to advise and assist the Planning Commission in its deliberations or developing findings and conclusions, whatever you would arrive at. Following that meeting on the 21st, representatives of the hospital and the neighboring property owner agreed that they wanted to enter into additional dialogue and discussions to see if they could find some common ground. Those discussions have concluded, and I don't want to misstate or overstate the conclusions, but essentially the information staff was provided was that Mr. and Mrs. Morse, who own lots 4 and 5 on the east side of Holly Lane, have withdrawn their objections to the addition of the office and clinic space for Viridian Behavioral Health, subject to certain conditions and limitations, and they are in favor of the addition of the use of the physical modifications needed to accommodate Viridian, to the construction of paved parking, to the continued use of the building entrances as they are today, and with the modifications of the signage to accommodate information about Viridian Behavioral Health. They predicated that change of position on 3 items, one of which may need to be clarified, but the hours of operation being from 8 a.m. to 8 p.m. Monday through Friday, the square footage limitation in the original conditional use permit remaining in place, and then there was concern if there was a continual gathering of persons smoking cigarettes outdoors as a result of the addition of Viridian to this facility, and if that becomes an issue, then the regional health owner would agree to construct a smoking shelter. And so basically, if those were the items of condition or limitation. And now if we look at why we're here today, there was so much additional information and testimony presented at the May 21st meeting that Mr. Luckman, legal counsel, advised that to properly conduct the Planning Commission public hearing, you needed to have access to that same information. So you have a very thick packet up there, but that packet contains written testimony that was presented at the May 21st City Commission meeting, as well as additional appraisal information that was supplied both by property owners and by Salina Regional Health Center. And so those things are all included in your packet. So you are under no obligation to reverse your decision, but you are under an obligation to look at any and all additional information that's in your packet or is presented today at this hearing, and see if there is a majority who either want to reverse your earlier decision or maintain your earlier decision. The main thing that we have done, just as food for thought or discussion, is on page 10 and 11 of your report. We have, in no particular order or importance, and you'll see some of those are alternatives to each other. We have just listed out possible conditions that could be considered on any conditional use permit in this regard. In terms of the size of the building, we wanted to clarify the current building is 16,000 square feet. The original conditional use permit that was approved in 2004 authorized a building of up to 26,000 square feet. So one of the things that the commission would have to consider is whether the existing building is big enough and should not be modified or expanded in any way. So that addresses items 1 and 2. Item 3 just further delimits that this is limited to being a single-story facility plus basement, and there can't be any changes to the residential design, appearance, or exterior building materials. Item 4 is a fairly standard condition, but it also adds a provision that says there can be no modifications to the floor plan that would completely eliminate the hospice portion of the facility without coming back to you for a public hearing and review of that. Item 5 is not an item of interest to the Salina Regional Health Center, but from a professional planning standpoint, it would not be responsible if we did not at least throw that out, that one option for mitigating impacts of the additional activity there would be to orient the primary entrance for Viridian to the expanded north parking lot. Again, that's not something that Salina Regional Health Center is interested in doing. 6 and 7 throw out alternatives as far as hours of operation, 8 to 5 or 8 to 8. Item 8 there addresses a concern about outdoor smoking, and then item 9 would indicate that this, if it was approved, that this is not transferable to another owner, so you wouldn't have some outside party coming in and operating a clinic here that was not Salina Regional Health Center. So if we look at your options today, you should open the public hearing and hear from all interested parties, and at the conclusion of that hearing, you could approve an amended conditional use permit as requested by the Salina Regional Health Center. You could approve that subject to any conditions or revisions being made to the plan submitted by Salina Regional Health Center. You could postpone consideration of the application if you still think you need additional information about traffic or parking or building entrances or anything else that's of importance. Or you could go back to your earlier decision and deny the amendment request if you don't think findings can be made to support it, or that what is being requested is incompatible with the surrounding neighborhood. what will occur is that your decision and whatever findings and conclusions you reach today will be communicated back to the City Commission, and they will have the final decision. But they wanted to hear from you after you had the opportunity to have the same information presented to you as was presented to them. So I think what we should start out with is any questions you have about the background or any information in the staff report or lack of information that you might see. And then if you have any questions of me or Mr. Luckman, we could start there. Otherwise, we should hear from interested parties.
Commissioners, any questions? I have one. I think just a point of clarification, it may be for Mr. Lockman or it may be for staff, but if you look at the zoning ordinance, I understand that we have denied this application twice, and according to the ordinance, it looks like the City Commission is the ones that now make the decision. I'm just not clear on why it's back before us for the third time. Am I misunderstanding that?
I don't think it was denied twice. I think it was sent back for clarification, which wouldn't have been a second denial. Am I wrong about that?
You misunderstood the
No.
staff report.
There has been one action by the Planning Commission, and that was to not approve it. And then you had a subsequent meeting where you provided additional reasons for why you did not approve it. The way the ordinance is written, it does not allow the City Commission to overturn you the first time if they have something they want you to consider or additional things they want you to look at. They're obliged to send it back to you, and then you, as a commission, may either send back the same recommendation or you can modify it.
So that second meeting where we again made a motion to deny it is not considered
That was not a decision, it was your
That was more review.
findings
That
and
was just,
conclusions.
we were clarifying for the
We were
commission what the
clarifying
reasons for
what
the
the reasons
denial.
was for your decision so they could see
And
that.
that was probably an error on our part not to provide that information to them. So,
Okay.
they wanted to know why.
All right, now I understand.
The second meeting was to tell them the why, the first meeting was to tell them the decision.
Thank you.
And I assume that a lot of the information about that's new is all going to get presented to us here shortly, but am I reading that there were questions about the value, effect on the value of the property? I mean, I saw a range there of 50% to 99% in one perspective, and then another nothing to 5%, so.
You had some appraisal information presented to you, but there was further appraisal information presented both by an appraiser working for Mr. Morse and also by an appraiser retained by Salina Regional Health Center. And that information was not available to you at your public hearing, and then the other, there was quite a bit of additional elaboration and testimony about the nature of Viridian's operations, who their clientele was, how and when they're open and their busyness, those types of things. So I guess that would be the main, if there's anything in your packet of information that somebody had a specific question about, we would try to answer that, but if not, I think we should move on to the public hearing portion and hear from the applicant, Salina Regional Health Center, and then from any other interested parties.
One more question from me that goes to probably the planning staff that I don't recall ever seeing, but in the original preparation of the conditional use permit for standalone hospice, did they do traffic study for that in anticipation of it being a fully used facility? It's only been used by half. Could we assume that the original traffic count they considered was double what it is currently?
Well, what was originally proposed was a 26,000 square foot facility, and what the Planning Commission considered at that time had a potential for another wing coming off of here and up to 24 beds. So what was analyzed in 2004 was a 26,000 square foot facility that had up to 24 beds, but was in fact a 100% a hospice facility, and the trip generation and the frequency of something like that, which is closer to a nursing home or assisted living facility, is much lower than a similar size facility that is a medical clinic or office in terms of trip generation or frequency of trips. So what was evaluated was a 26,000 square foot hospice facility with up to 24 beds.
I guess what I'm trying to get in my mind is that if we're saying we have 60 trips more a day with the Viridian inclusion, what was hospice originally planned, 40 more? Are we looking at a difference of 20 with this change of use? Or is it substantial from what was prior considered?
It is all just projections, but I think you'll have to judge that for yourself. But the primary distinction is that for nursing home, assisted living facility, a hospice, the trips are infrequent, as opposed to if you have a medical clinic or doctor's office with hourly appointments, the comings and goings are going to be more frequent, even if the total trips might not be that big a difference. The primary difference is going to be the comings and goings versus at a long-term stay facility, then the trip is in, the trip is out, but the trips might be 8 hours apart, whereas at a medical clinic, the trips might be 1 hour apart or half hour apart. It's going to be the frequency of comings and goings.
Well, talking about traffic, is there any accident history at the Upper Mill Heights intersection, which is only a couple hundred feet west of this and on the opposite side of
We've got Mr. Stack here that might be able to speak to some of that.
I would assume that there are many more cars a day going through that intersection than would possibly be coming out of Hawley, even if you went with the whole office counseling concept. And it's very much the same situation. The visibility is not very good. There's cars coming down the hill sometimes at extra legal speeds. And there are a lot of people turning left in the afternoon, even though there aren't in the morning.
Dean, do we have a count on the number of lots in the Upper Mill Heights? Did you say Upper Mill Heights, or did you say Victoria Heights?
Victoria Heights.
Victoria Heights.
I was talking Upper Mill Heights, which is the closest intersection, not Upper Mill, but the one that's right across to the north.
Across the street north.
From Hawley.
Okay, we can check. I'll check. We don't know of any there as far as, I mean, as a major problem. We haven't, but we can check and see how many there's been, if that's the question.
Shall we hear from the applicant? Mr. Hennenkamp? Thank you.
Thank you, Mr. Ryan. My name is Jack Hennenkamp. I'm representing Salina Regional Health Center at 400 South Santa Fe in Salina, Kansas. First off, I'd like to thank you for your time again to hear our appeal on this, as well as that of city staff and their assistance and the assistance of others in preparing the information. Our purpose here today is for Salina Regional Health Center to respectfully request that the Salina Planning Commission reconsider and reverse their determination from April 17th, from the April 17th meeting regarding application CU03-2B regarding Salina Regional Health Center's placement of SRHC's Viridian services in the Salina Regional Health Center Hospice Facility at 730 Holly Lane. This request incorporates all associated issues we raised at the time, which related to the minor site modification that would be necessary, including the additional parking lot, the plans for some basement renovation that would not be visible from the outside, the signage adjustments, the days and hours of operation being from 8 in the morning until 8 in the evening on those days when that was necessary. I think Dean Andrews has given a good background, and I'm willing to respond to any questions you might have, or if there's some other background that I don't cover, please feel free to ask on that. But I think he's given a history and included that in the materials that you have. As I noted at that first meeting, it was with a with regret that we found ourselves in a position where our hospice facility has not turned out as well as we had hoped. After 5 years of effort, we have unsustainable losses in the neighborhood of about $2.7 million since October of 2008. Our desire is to continue to keep hospice operational, to make that facility work, and to be prepared to, should further business develop with that. We don't wish that on anyone, but if that is a need of a family, we want to be able to provide that. But in the interim, we could not continue that sort of loss. We have a program, a Viridian Behavioral Health Services program for counseling, as I had noted at the last meeting and at the City Commission meeting, that has outgrown the space they have in a location where we desire to place additional physicians for the community to serve the community. And with an underperforming facility that has a lot of unused space, our objective is to place that space, which we feel is compatible with hospice operations, at the hospice facility at 730 Holly Lane. From our end, the counseling does deal with the hospice patients, or can certainly deal with them and include them. The Viridian needs about 8,500 square feet. They're in about 5,500 square feet right now, and we can't expand. In the evaluation, we determined this facility was ideal because it required, other than those noted, no additional facility external adjustments. A couple things I'd like to clarify that were raised in the City Commission and City Staff report. It's true that this will change the complexion of hospice to some degree from a full hospice to a mixed facility, mixed medical facility. But hospice will still occupy 2/3 of the space, with Viridian occupying approximately 1/3 of the physical square footage of the plant. On page 5 of that City Staff report, it noted that it would clearly increase the traffic flow, and we don't disagree with that because our hospice has been underperforming, and we'll have some additional figures on that here as we go through this. We would agree with that. It will, but we're well below what was ever anticipated or what the street is capable of doing. At this time, what I'd like to do, and another issue that came up was the visibility constraints, and it's even been mentioned today. If John would bring up the photographs we took of how, I'll be looking for the ones along Crawford Street there. This is a view from Holly Lane looking to the west. I'm not sure why we talk about impaired visibility. I don't see much in the way of impaired visibility at this location here that would create an incident. Coming from the east, it's a little bit different, but still I think visibility is adequate, and from this picture you can see there is an opportunity to see traffic. We certainly have many, many, many areas in Salina, Kansas that do not have this level of visibility available for traffic. Just to compare that, I did take, with the next street down that enters Victoria Heights, this would be their view. The view at Holly Lane clearly is far superior to the issues that we would see here. And then if we look at the east, it has a good visibility coming if you were wanting to go across the street. So as I compare that with other areas in town, I did not really see this as an issue that's been raised as an extreme concern. I'll have a little bit more on that as we continue through. I'd like to cover quickly. There were 6 issues that were listed in the report for the Planning Commission to address. One was they must find the proposed conditional use will comply with applicable zoning. I don't think there was ever any question on that. It was agreed to. The Planning Commission must find that off-street parking and loading areas will be provided. Clearly, our plan shows that those provided for would not be adverse to this. The Planning Commission must find that adequate utilities, drainage, and other necessary facilities do exist. Clearly, we have those exist. They were demonstrated or stated by the city that they would meet with the changes that we had. The Planning Commission must find that adequate access drives will be provided and designed so as to prevent traffic hazards. We feel that that's clearly been demonstrated both by the city and by ourselves here. The 5th item, the Planning Commission must find that proposed conditional use in this location will contribute to the welfare and convenience of the public. This was presented in detail at the time and also at the City Commission, that allows expansion of the service in a facility that already exists and can provide services where sufficient space does not exist at their current location. It also makes best use of healthcare dollars by using an existing facility. It provides convenient access to counseling for hospice patients due to the proximity for family and the hospice patient. It provides a service in an ideal setting that is similar to surrounding residential locations such as Pawnee Mental Health in Junction City and Prairie View Mental Health Center in McPherson, Kansas. This location will contribute to the welfare of the public, community, and region because it exists, has available underutilized space, and by using it prevents the possible creation of a derelict building and site. Sixth item was the planning commission must find that the proposed conditional use will not cause substantial injury to the value of the other property in the neighborhood, and that it will not dominate the immediate neighborhood. You have in your packet the appraisals that were done. One listed as much as a 99% reduction in value from the property, from one property, which was 731 Holly Lane. We did not think that was inaccurate, that the property could be reduced by 99%, up to 99% from that. It did not list any other properties that they felt would be devalued in any way. We did engage two appraisers. They did come back with 5% on a 6-month basis if it was affected at all for the 731 property and no other properties in the immediate area. I would let those reports stand for themselves. Be glad to discuss those further if you have questions on them from the information I would have. The one other thing that I might notice, the other thing that I would like to do is show the pictures we have of, because there was some thought that, well, it creates an issue for properties on Victoria Heights Terrace and Victoria Heights. If we could show some of the pictures looking to the east that we had. These are the views from the hospice facility and hopefully hospice Viridian facility as you look to the east, and obviously if you were on the other side of those trees you would be looking down. So as you can see from this, and if John will show the next two or three, the house you see here is 731 Dana Morse house that was taken there, so you can kind of see a little bit of shadowing of that. But, next one. Another picture looking across from Meridian Hospice, from the hospice facility towards that. So from our perspective, we don't see how Victoria Heights and Victoria Heights Terrace is impacted at all by this, since that would really not be visible from the location they're at. There's distance and there's elevation changes that do not affect that. We did feel that if there was any impact at all that would affect the Morse property, and we worked with them on that issue. The last thing I might include in this category is Mr. George Johnson, who lived there, was also in opposition to the development of the hospice facility when that took place, advising that it would decrease the property values in that area. While we didn't agree with that, I did want to point out that the property had sold. The time I said this, it was more recent than it is now. We're 4 months further down the road, but that house was appraised at $344,100 at that location, and it sold for $390,000. So clearly the hospice facility had no adverse, and the hospice facility appearance does not change in the least. There is no change in what people will see. The last component of the statements I'd like to make have to do with comments that were made at the Planning Commission that I feel we did not really have a chance to address. One of the things that happens when you present your information to Planning Commission, it goes out to everyone. People see what you're going to say, but you don't know what the opponents or the response is going to say. So with those, we did want to respond to those perhaps more thoroughly than we were able to at the initial meeting. One of the statements made would reduce the safety of the neighborhood by the nature of the condition, the illness of the patients, that they are behavioral health patients and needing professional behavioral health assistance. I have 2 or 3 people here today that will want to address that a bit further. They noted the children's playground was such that, gee, would anybody want to play on that with behavioral health patients? I mean, it's shocking language and thought process to me that would be considered. That does happen to be a hospital-owned playground there, and it's part of the hospice facility for children that would be visiting hospice. But we did not see that was a sort of issue that would be. To qualify for Salina Regional Health Center Viridian services, the client cannot be a danger to themselves or others. So those that would fall into that category are not eligible even to be seen by Viridian professionals. The YMCA is adjacent to Central Kansas Mental Health Unit. They do see a wider variety of persons. We do. Oakdale School is a block from Wellsprings and Three Rivers. And the Kids at Child Center in McPherson, Kansas, immediately adjacent to Prairie View Behavioral Health Unit, all that operate similar services or more advanced from the perspective of needs for care. And they're adjacent to residential areas. 2, the high increased volume of traffic flow would be adverse to an otherwise quiet residential area and create safety issues, was a statement that was made. The volume of traffic that we proposed or expect, and this was to a degree corroborated by the City of Salina and by our own staff, looked at 60 to 80 in and outs daily. There would be no more and much less than the amount of hospice traffic that would have been experienced had the hospice program met its desired potential. The building facility was granted for approval of 24 inpatient beds and outpatient hospice and administrative staff support with attendant vendor and other facility support traffic. The director of our hospice program notes that a minimum daily in and out trips for one patient would be around 12. We say, well, there won't be that many, but when you think of a person in hospice, this will probably be one of their last homes here, and you've got a number of relatives that come and see hospice patients, people that may never see them again, that want to see them and want to visit for extended times. So there is a fairly high volume of, or can be with hospice patients. If you carry that number to the 24 patient unit, that would be 288, which is well above the 60 to 80 that we're talking about that would be added. And once again, we have never met the expectations of hospice from a patient volume perspective. Holly Lane was designed and built and classified as a local residential street. The addition of Meridian is estimated that would increase volume traffic by 60 to 80, as I've noted. An average residential local street has around 300 vehicle trips per day, according to information received from the City of Salina passing in front of a home. There are much higher counts with adjacent schools. The zoning is R. The number of lots in the area where the hospice facility is developed was to be 10, and I always say 10 to 14. I can't remember. Is the 4 across the street on the east side?
There was original plan for 10, and when that didn't seem to be feasible for infrastructure, it was increased to 14 on the west side.
All right, thank you, Dean. So 14, that would be 140 trips using the city mean of approximately the average number of trips as being about 10. Once again, far less than we're proposing to have added as a result of the Meridian addition to that location. So we're well below that and well within the city capacity identified for the street. By way of comparison, Crawford Street, which is classified as an arterial street, carries between 13,000 and 14,000 vehicles a day between Ohio and Marymount. And along that route, there are many, and if we take a look at Crawford, 9th Street, and Broadway, and Santa Fe, there are many residential properties that dump right out into an arterial street with much higher traffic volumes than we're proposing here, without the incidents and the creation of the hazards that have been proposed that would take place here. That simply is not going to exist. I might note the last piece of information that came in as written testimony was August 16th from David Sanderson. Expressed the concern that they're concerned for the traffic, the visibility, and that they have young people that will soon come of age and be able to drive there. I would say this is not going to be the worst situation they face by having 60 to 80 cars a day, which represents less than 1/2% of the total average daily volume on Crawford Street. I don't think those are legitimate arguments to say that traffic is a big concern along there. Clearly, hospice has very exceptionally low traffic impact, and it's not meeting the expectation of use. But one of the things I want to note is one of the greatest safety issues that can exist on a residential street is on-street parking, which is very unlikely to ever happen with the off-street parking we're going to provide. That is something commonly seen in typical residential streets, and that is probably the greatest hazard. We're not going to have that, so we further reduce the hazard that's been identified as something that would be coming about. It simply won't be the case. We talked about, it was mentioned that it would be pedestrian traffic hazards. There's one house on this property here, which is the Dana Morse property. It's a man and his wife. I think they have grandchildren, but there are no other properties. There are no other properties where there be pedestrian traffic. So I'm not sure how that was an argument even to be brought up at the previous meeting where it was raised by at least one person. Todd Welsh, a person I respect very much, and I think he's done great things in Salina, did present at the Planning Commission. He recused himself from voting, but he did present in opposition to the SRHC proposal, noting an adverse effect regarding a previously unannounced and not fully explained at the meeting possible development across the street from the hospice facility, which I'm not sure the land was in ownership at the time, or if it is now. It was indicated that Meridian use would adversely affect, if not completely stop, the development believed on the nature of the Meridian clientele type and for street safety. I've addressed those issues, I think, but I'm glad to pursue those further again. But I would hope that the Planning Commission would give more value and consideration in the review to an existing facility that fits the qualifications for a conditional use by definition in our district as opposed to a possible, not fully explained, maybe developed property, admittedly not yet under the developer's ownership. And if Todd speaks, he can address whether that situation has changed. But my point is, I guess, we're asking for something that exists, that will not change the exterior, that already has traffic patterns to it, that will not exceed, and is a development in play. And what we propose does not prohibit development on the east side of the Holly Lane at all. The adjacent residential property values may decline as a result of hospice, and I kind of addressed those with what we had seen from appraisers previously. One comment that was made by a planning committee member was the neighborhood should not be expected to suffer an unwanted use just because SRHC made a decision to have a hospice development that has been losing money. I think anyone familiar with what existed previously and what exists now would agree that the improvements in services is not representative of the neighborhood suffering. A high-quality road exists, improved utilities are in place, professional landscaping is in place, a quality building is positioned on property that is well-maintained and equivalent of any property in the surroundings. Placement of Meridian services at that facility and attendant activities would not be adverse to the neighborhood. The use proposed is allowed by an ordinance for an R district. It does benefit the community and will not hurt those making such statements. It is difficult to understand the position of Victoria Heights. Remember the pictures and the elevation we had would suffer from this proposal. Another statement was made, the hospital has plenty of property at its main location and others that could use for program development rather than the hospice location. The statement that Salina Regional Health Center has plenty of property at its main location, I do not believe is from a person that would be fully informed of the plans and operations of Salina Regional Health Center. I've noted the reason that Salina Regional Health Center is looking at this for Meridian. It can go to that location. It fits that location. It provides the additional space, and it gives us room to place additional physicians coming into the community that will serve Salina and the surrounding region. In the last 3 to 4 years, Salina has brought in 40 physicians into Salina, Kansas, and this is something the community wants and the region wants and needs. Having medical office buildings we can place them in is a real selling point to having them here. As I noted earlier, the Salina Regional Health Center desires to retain hospice operation, but can only do so by making better use of the facility to mitigate the losses and spread those out. It was stated by one member that the hospital stated they wanted to consolidate their properties for efficiency as a result of the HM, and as a result, the HM zone was created for doing that, and we should plan on placing services there rather than other locations. Clearly, we plan on placing other services in the HM zone, but I don't believe that is applicable to this request. The purpose of the HM zone was not to eliminate SRHC from having any other location for the delivery of health services within the community, but it was to address unique issues specific to the downtown area of Salina Regional Health Center. Salina Regional Health Center has worked with Foundation for developing the Children's Center on Ash Street and Hospital Computer Center on Iron Avenue, which are not in the HM zone as well. We had a few other issues I would call kind of housekeeping or make sure clarifications. One of the things Dean alluded to, that if the hospice was allowed, hospice and Meridian were allowed, that there would be consideration of a backside entrance. We would request that not be included in any consideration or motion that would be favorable to the overall request. The intent is to make use of the facility generally as it is. No one would really know the difference whether they're in from the back door or the front door, but it would be a tremendous facility expense to change that whole facility around to create a main entrance on the back side. The only entrance that exists now is intended for staff and enters through a break room. The volume of traffic would not be changed by that. There would be nothing changed. You saw that visually there would be really no reason for those that would be there that might express a concern to be concerned with that. That is not the way you'd want your community health dollars spent. If permitted, all conditions that applied to the original condition use that permitted hospice should apply, and we would agree to that, related to height restrictions, general layout, and landscaping. We did request that if permitted, that rather than saying you cannot build an extension on, we would stick with the 26,000 square feet total that was allowed at the time of the original application. Once again, our hope is that hospice does become a need that serves the community with an aging population, should it be needed in that capacity. If permitted, the hours of operation be restricted to 8 to 5 was noted, and Linda Simpson here would address that further, and others, but we really need to operate 8 to 8. There are still places in the community where people feel that they cannot tell, sadly, They cannot tell their employer that I'm going for a mental health appointment or behavioral health appointment, and there are people that have children in school that need to go, and the only way they can do that is to meet with the counselors after 5 p.m. So we would like that to stand as was requested. I don't have anything else at this point in time. I'd respond to questions. We do have some behavioral health people, since that was such an issue last time, the concern of that. It was well addressed at City Commission. We'd like to be afforded the opportunity to do the same thing here today.
Questions?
Mr. Hennekamp, could you go back? You made a statement about the nature of the patients at Viridian, and maybe this is
If you don't mind, I think they can cover it better than I will, but there is a limitation on who they treat, and I think Linda can elaborate on that as well as others, if that would be acceptable, Mr. Mikesville.
And does the hospice have any cutoff hours right now?
They do not. I'm asking Denny, I guess, no, they do not. We have the director of hospice here if you'd ask questions specific to him as well, but they do not. I mean, it's designed where people can come at any time.
If this were considered by the commission, you mentioned that the space that Viridian's currently in would be used for physician recruitment for offices for
That's correct.
Mr. Hennekamp, the 3 exceptions that the Morrises wanted, you're okay with the things that they wanted to see happening? They withdrew their objection to this.
One was the smoking shelter development, should that become necessary. The other was operating 8 to 8, which is what we've asked for.
And the square footage of 26.
And the square footage staying the same as what we've asked for. The other issue that I think Linda would address is I don't know what they have in the way of group meetings. That was something that was mentioned that I did not address, that not allowed at group meetings. I don't know they do much, but Linda could better address that. I think it's limited, but she might address that further. That was a question remaining.
Any other questions for Mr. Hennekamp?
Thank you.
Thank you, sir. This being a public session, we'll open this to the public, and you can.
Hospital representative.
And if we'd like to hear from the hospital representative, I'm cool with that. Good place to start.
Good afternoon. I'm Linda Simpson, Director of Psychiatric Services for the hospital. I'm a registered nurse and a licensed clinical professional counselor. After our last meeting with you, we walked away with, I think, 3 unanswered questions. Who are we and what services do we provide? Why put hospice and mental health services together? And there was also references to our clients not being safe. As far as who we are, our hours of operation currently are Mondays 8 to 5, Tuesday, Wednesday, Thursdays 8 to 8, Fridays 8 to 5. We allow those evening hours for kids. We work with a lot of kids that struggle with poor grades or truancy issues, so we try to allow some afternoon and evening appointments for them. I think it's kind of fruitless for them to be pulled out of school to see us, so we do offer those hours 3 evenings a week for them, and also to do some family work with parents that can't get off from work that'll come in with their kids after hours. We're closed on weekends and we're closed on holidays. As far as services, the majority of Viridian services are geared towards individuals and families who are struggling with common life problems: depression, anxiety, marital issues, grief and loss, parent and child conflict. I say common life problems. I pulled some data that I shared with the commissioners from the National Institute of Mental Health. As far as anxiety disorders, 40 million Americans ages 18 and older, so about 18% of our population, struggle with an anxiety disorder each year. Depression affects more than 21 million American children and adults. 9% of our kids ages 13 to 18 struggle with ADD or ADHD. The Center for Disease Control shows that about 25% of our U.S. population has some sort of mental illness that they struggle with. As far as marital issues, if you look at our divorce rates, 50% of first marriages, 67% of second, and 74% of third marriages end in divorce.
Wow, why do people
For these,
do that?
I know. For these reasons, we provide family counseling, marriage counseling, Christian counseling, life transition, end-of-life issues. We have a lot of hospice clients or their kids, family members that we work with. We work with people who are diagnosed with serious medical conditions. We've recently partnered with KU Med Center and Tammy Walker to help with people struggling with cancer. We provide psychological testing for kids to qualify for additional services through the public school system. We do all local law enforcement assessments before they hire police officers in the community. We provide Kansas Highway Patrol training, Department of Transportation evaluations. We work with active duty and National Guard troops and their family members. We provide services to OCCK. Dr. Cox and Angela Corporate, one of our nurse practitioners, does nursing home rounds in the community. We provide the following employee assistance programs for companies and organizations in the Salina area. We work with Phillips Lighting, Tony's, Great Plains, United Postal Service, Crestwood, One Oak, United Way. We provide services to Central Kansas Mental Health Center their employees if they have struggles. Lindsbrook Hospital, we provide services for City of Salina employees, State of Kansas employees, Salina Regional Health Center, Sunflower Bank, First Presbyterian Church, First Baptist Church, Blue Beacon. Not as frequently, we also work with ADM and Exide. Why put hospice and mental health services together was the second question. A lot of my information I'm going to share with you comes from the Hospice Alliance website, the American Psychological Association, and the National Institute of Health. Prior to any administrative conversations regarding finances, our leadership team, which consists of Dr. Yurkovich, our medical director, Shayla Kuchel, our inpatient supervisor, and Stephanie Sutton, our outpatient supervisor, we were in conversations with Benny, the hospice director, on how we could partner to provide services to their employees when they struggle with loss and additional support for those family members. If you Google mental health and hospice, you'll have tons of information that pops up for you to show how those two services do go hand in hand. Viridian therapists already provide services to their family members. If we were able to be out there underneath the same roof, it would be quicker and easier access for their family members. We can also help family members and patients if there's resistance to accepting help or accepting change. We're trained to do that. There's also, for anybody who's lost a family member, sometimes there's emotional or psychological unfinished business that we can help them ease through that also. Also looking at diagnosing and treating any bereavement that kind of spills over into depression. We can help kind of differentiate that for the hospice staff. And when a hospice patient's struggling with unmanaged anxiety and depression, research shows that can have an impact on care provided to them. Psychiatric Services Journal, I just pulled this excerpt out of there. Psychiatric symptoms can have an effect on physical health, quality of life, and ability to respond to disease-modifying treatments for hospice clients. They can also interfere with the patient's capability to make decisions, understand his or her treatment, interact with caregivers, or reach their final goals. The need for mental health services and mental health clinicians to work with patients and families living life-limiting illnesses have never been greater. Timely and accurate psychiatric assessment, diagnosis, and treatment are needed if a meaningful end-of-life experience is to be achieved. The third question we walked away with was references to our clients not being safe. I think a couple references were made to and used the word antisocial. The Department of Health research that I pulled up, most people with antisocial personality disorder in the community remain undiagnosed and untreated. They do not come into contact with mental health services and often do not perceive any need for treatment of their personality disorder. I know today's media, there's always reports about mental illness and how they link that and the tendency to overemphasize violence and mental illness. So I started with, and it's in your packet, the National Children's Alliance statistics. And I want to flip to and share with you. Because I think I looked this up after the references are made about if our clients were out there, that kids would not be safe playing on the Salina Regional Health Center playground. 2011 data on the statistics looked at alleged offenders, and there was 226,000 of them. A little over 88,000 were parents or step-parents of the children. A little over $47,000 were related to the victim but not a parent. About $72,000 were unrelated to the person but the victim knew them. So looking at this data and child safety, there's not a lot of data supporting random acts of child sexual abuse on a playground. I also looked up the Salina County Registry and I went through it. On the Salina County Registry, there's violent, sex, and drug-related cases. Of the 181 people listed on our registry, we provide services to one of those clients, and it's not a sexual-related offense. Then I emailed, and there's a copy of it in here too, Sheriff Kokonowski, because I emailed him dating 5/8 and asked him, in the last 5 years, have you ever had an incident where you've brought clients to us and something's happened? And he put in here the planning, he was wanting to know which planning commission meeting I was referring to. He said, in checking with the jail administrator over the years, we've taken a couple of individuals to Viridian, some are seen at Salina Regional Health Center, and numerous at the local mental health center, who usually refer them on to Larned State Hospital. All that we deal with are taken to various places of the above and released. I hope this helps. I don't know where the dangerous concept comes from because most of the people we deal with are fighting their own personal battles and need help. And he again goes on to the majority of clients that inmates he has goes to the mental health center. But I did send him a follow-up email on May 18th saying if and when we're able to move our mental health services into the hospice space, that we would no longer allow inmates to come out there for services, even though I don't agree with it and don't agree with the philosophy. I told him that we will do everything we can to either go to the jail or he can bring them on site on our campus there at Salina Regional Health Center. But if we're able to use this space, he knows, effective, I said effective May 21st, but if we're able to go to that space, that he'll no longer be able to bring inmates to Viridian. Asking about us if we would be good neighbors. In your packet, there's a letter from the office manager for Salina Urology Associates saying, over the past 5 years, our association with Viridian has been a good one. We've not had any negative incidents with Viridian clients, nor have we had any concerns. I'm sad to lose the friends I've made next door, because if you go into our office, their front door is right next to ours. Share the same hallways, elevator, parking lot. And I had Joyce Trower, who's director of the Infant and Child Development Program, work with special needs kids birth to 3. They share the space. Well, they did. They moved into that new building, but they shared the space right below us. And our patient population and families, this is an email dated April 24th that you also have a copy of, have had absolutely no problems of any kind in sharing public areas with Viridian clients and staff. Areas we share include hallways, elevators, public restrooms, parking lots. Viridian continues to be a good neighbor to our staff, parents, patients, and others who are involved with our agency. In the period of time we've shared this building, we have never had a complaint, a concern, or an issue voiced by one of our hundreds of persons who have been in and out of our department. Please consider this my recommendation, that Viridian be considered a very appropriate candidate to inhabit a portion of the hospice building. Signed, Joyce Trower. During our presentation to the City Commissioners, I thought it would be helpful to give a voice and a face to our clients. We did have some clients volunteer to do that. We had a woman share her struggles after losing her leg in a local factory accident. She lost her leg. I went with her, worked with her in the hospital, and then we did follow-up work with her at Viridian to help her make that adjustment. We also had an Iraqi war veteran talk about his PTSD diagnosis and treatment. Had a gentleman who works for the National Guard, recently went through a divorce, and we've helped him with that. The former editor and publisher of the Salina Journal discussed how he's been able to effectively manage his depression over the years. But after the presentation, I walked away thinking, I missed a key piece of what we do, which is children and family services. I was reminded of this just last week when we accepted, and they're here with us today, Mr. and Mrs. Katzenmeyer. We accepted a memorial following the death of their son. They made a donation to cover the cost of individual therapy for uninsured kids in our community. The Katzmeyer family had both of their sons as teenagers, so I think it was 20-plus years ago, 20-plus years ago, as access services to help them through their teenage years. And we've also had the privilege of the second generation helping one of their granddaughters access services, and now she's actually second day at K-State Salina, so we wish her good luck. I asked them to share their story with everyone today, but Mrs. Katzmeyer quickly responded, "I don't public speak," which I said, "Me neither," but here I find myself again doing this. But she was willing to write a letter for her granddaughter to read, but because of school and work, Kayla could not be here. So I'm going to have Stephanie Sutton just briefly share what they wrote that they were hoping to share with you today. Stephanie Sutton's our outpatient supervisor.
Thank you.
This was written by Kayla and with the help of her grandmother. My Uncle Shad was my father's younger brother. He was 38 years old and very recently passed away on Sunday, July 29th. My grandmother was adamant that the memorials from his funeral be designated to Viridian due to the impact that the counseling he received here from Mark Crow so many years ago that gave him the confidence he so desperately needed to succeed in life, and succeed he did. Our entire family was very proud of Shad, yet his parents don't feel they can accept much of the credit for his successes because it was his time spent here at Viridian with Mr. Crow that he learned to focus on the positive aspects of his personality and his intelligence. And as a result, he had many more friends than most of us could ask for in a lifetime, and was so talented in his field of expertise that companies all over the United States would get into a bidding war over his talents. My father, Shane, was first at age 14, the first one in the family to access services at Viridian. They had such a powerful impact on his level of confidence that my grandmother has asked Mr. Crow on several occasions to please undo whatever he did to my father, because he went on believing that he was from being totally worthless to becoming very overly confident. My grandmother says that much of this could be perceived as being too arrogant, but she's very thankful. My Uncle Shad was bullied as a kid, as many children are. He was told he was stupid or he couldn't read as fast as everyone else. My grandparents were never quite sure how Mr. Crow was able to help their grandchildren overcome their insecurities, but that he did, and was most blessed as a result. My dad and Uncle Shad retained everything that they learned during their therapy, which in turn they learned to live much happier lives and always show respect and compassion for everyone else's differences.
In summary, I just hope and pray that you reconsider your initial decision and allow us to put mental health and hospice together in the same building. Thank you.
Mr. Henkamp, is there more from the applicant's side?
I think that covers the official one. There may be some other people in the audience that can comment.
Okay. Well, then we'll continue with the public portion, and if there's anybody that'd like to address this issue, you're welcome to come forward. Please state your name and address for Crystal's record, please. Mr. Morris.
Hi, my name's Dana Morse, 731 Holly Lane. Believe it or not, I'm going to keep this really short. Since this application was submitted, Ginny and I have been very close at what was going on, personally involved. After the City Commission meeting, when the application was returned to the Planning Commission for further consideration, we began to understand that there were many occurrences guiding us, and there were just too many for it to be a coincidence. We spent many evenings discussing what was going on and decided, instead of stressing over the future of the neighborhood, that we'd change the direction of our lives. Coincidentally, or ironically, whichever it is, Blue Beacon announced my pending retirement today. Ginny and I have a buyer under contract for our home, and that buyer knows that this application for Viridian Services to be in a neighborhood could be approved. Working with Jack at the hospital, Ginny and I have come to some agreements on most of our concerns. So our plan is to sell our home and move out of state and spend more time with our grandkids. I want to thank you for all that you've done and your attention and hard work on this. If you have any questions of me, I'd be glad to answer them.
Any questions for Mr. Morris? Thank you. Are there others that would like to come up and speak to the commission?
Good afternoon. I'm Brenda O'Gorman. I live at 705 Victoria Heights Terrace, and I come as an opponent.
Talk into that just a little bit, because it'll make the lady in the booth that keeps track of everything much happier.
Okay, I come as an opponent of the application. First of all, I'd like to say that coming here was not pleasant. I was here on the very first round when you were considering the application to build hospice at that location. And I want to say that the original zoning change for hospice was restricted to a residential nature to help appease the neighborhood about the concerns that we had about commercial development being placed, butting up against our properties. And it was intended, I think, to as a compromise to protect the Victoria Heights neighborhood. And should this pass, I know it's the feeling of myself and I know some of the neighbors that that promise will be broken, both by hospice and the hospital and also by the zoning commission. This is what destroys trust in government and in business ethics in the community. We were assured of that, some of us, when we bought our properties, that this was going to be a peaceful neighborhood. I'd like to talk about the hospital district, or the hospital was given a designation of a hospital district in downtown Salina for planned commercial development of the hospital. And I'd like to say that in all other communities within the state of Kansas, I'd like to say, quote directly, that be Wichita, Hutchinson, Manhattan, that have passed a hospital district zone for hospital use, restricted their hospitals specifically from not having any other commercial development in residential areas. And I'd like to say that Salina has failed to do that, and if you pass this, what you're doing is opening the floodgate for commercial development to happen, not just adjacent to our neighborhood, but every other neighborhood in the city of Salina. And I just want you to understand how serious this is in nature, that it does set precedents. And I'd like to also point out that Salina Regional Health Center owns significant commercial property in town that would be a more appropriate setting for Viridian and would not encroach on the residential nature of the hospice facility as it currently exists. I know that Mr. Morris has visited with you this afternoon, and I would like to say that I know there was an agreement reached, and that that was in lieu of significant consideration. And I would like to say that in a sense, and these are my words, this person was bought off by the hospital, and I think that that's a direct admission that they agree that hospital values is affected by commercial property being adjacent to a residential area. And it does adversely affect the neighborhood and property values. I also want to go on record as saying both hospice and Viridian Health are valuable sources and resources in our community. I have no ill will from either one of those. But I would like to state in previous testimony, both before this commission and before the city commission, there were appraisers, two appraisers that gave testimony, but one written and one in person. And I am also a licensed real estate broker in the state of Kansas. And they both, and myself, state that it will significantly affect property values. by allowing commercial development to butt up to this type of residential area. Our other concern is the neighborhood, and for me, I don't sit on the ridge, I sit across the street from it, but my major concern is that by changing this zoning, it opens the floodgate for anything from a drive-through restaurant, a bar, a tattoo parlor, an adult porn shop, or anything else that would like to be placed in this, because there would be no zoning restriction. And I would also like to state that that would affect lighting in the area, signage, noise, and traffic. After also listening to the hospital's presentation, I would like to state that I understood, and my perception was, their evaluation of the traffic was based on their client use of the area. I would like to state just their staffing change has well exceeded the traffic that would have been projected by a hospice facility. Because you're looking at, I don't know the total number of their staff, but I'm going to project at least 15, maybe 20, 4 trips a day in and out. Because there are no restaurants or anything of that nature in that area presently, so they do have to make an in and out trip onto Crawford Street. Let alone that if they do have, let's say on a given day, 10 counselors, and each of them have 6, in an 8-hour day, 6 clients visit them, you can see the amount of traffic in and out that that creates. Now, to be honest with you, I was concerned about hospice, but after the limited use by hospice, obviously they were maybe 1/4 of their capacity at most times. It really didn't present that much of a problem. And because of it being residential in nature, when you're talking about your neighborhood or you're going to sell your property, you have an assurance that it's going to be somewhat in the same nature as the ownership of the property that you have. I would also like to state one caveat. The one property that they have quoted that was sold after the hospice property was developed, and I think there has been others, and none of those were referred to, but that property was, I want to say, it was a isolated incident. There were factors involved in that sale that is not typical in a sale. That was related to that property and the buyers. And so while I think it did occur, I would like to say that I think it was an isolated incident. And from my perspective, I would be thrilled to get the appraised property by the county if I sold my house tomorrow. But my major point today is to consider, again, putting our homes in jeopardy to butt them up against commercial zoning and what that does for future expansion of that area. And I would appreciate your denying the request. Thank you very much.
Thank you. Are there others?
Hello, I'm North MacArthur, and my wife and I, Dr. Deborah DiBiase, own the house on 746 Victoria Heights Terrace, which overlooks the city of Salina. I guess it's on the west side. However, we also own lots 2 and 3 and 6 and 7 on Holly Lane. I guess I read this following the May 21st City Commission meeting. Representatives of the hospital and neighboring property owners agreed to an additional dialogue and discussions, and owning lots 2 and 3 and 6 and 7, we weren't included in that, and I didn't know why, or if there was something happened there that we didn't know about. But Brenda did an awfully good job, and I want to thank you guys for listening to everything again. The commercial versus the residential, it's not Veridian, and it's never been about Veridian. It's been about, once we start the precedents, as Brenda said, what stops it from going on in your neighborhood, and your neighborhood. And as a planning commission and as a city of Salina, I think we need to keep everything in retrospect and know that, you know, once you open the door, you don't know where it's going to end up. I guess I can't stress the amount of value that probably is going to be lost, because I don't think anybody really knows till after everything's already said and done. Nothing, like I say, Brenda did an awfully good job of everything. Oh, and the view of everything, which I look at that during the summer, but in the winter there's no trees, or the trees that do don't have any leaves on them. So trust me, when you're up there, you can see down and you can see all of hospice. So anyway, thank you again for your time, and I once again echo what Brenda said, that you take a second look at this and also deny it, not because it's Veridian behavioral health, it's because we're starting a precedence, and I don't think we need to put commercial industry in our residential neighborhoods in Salina, Kansas. Thank you all for your time. Anybody have any questions of me?
Have you ever had any of those properties for sale?
Have I ever had?
In the time that you've owned them, have you ever put them up for sale?
No, sir.
Do you intend to?
I don't know. Give me an offer I can't refuse. Everything's for sale
Thank
tomorrow.
you. Would you call it a buffer?
Yes, sir.
Okay.
Any other questions? Thank you.
Mr. Chairman.
Yes.
I believe a point of clarification probably needs to be made, just to make sure. I'm not sure if you're all aware of this or not, and I want to make sure it's understood, and also if any of the folks who commented wish to address this point. There's been some talk here at these that there is an issue of you setting a precedent in some fashion by granting this, and I do not believe that's legally the case. As you understand, this is a conditional use permit. Certainly your approval of denial is based upon the application you have in front of you. Another application by another party for a similar request can be denied or approved for different reasons or other reasons. It certainly would be the case if you were considering an amendment to the zoning map, changing the designation to commercial zone or something like that, that would change a larger area. But there is no resulting allowance for other parties other than the applicant to build anything here that's of commercial nature because of this decision.
Thank you very much. That was clear in my mind and probably is in the other commissioners, but I'm not sure generally the public understands that. Are there others that would like to address the commission? Time is running out. If I close the public session, you won't have any other opportunity to speak. So if you have more to say or something new to give us, please do.
I would just like to ask the commissioners one thing. Is it not easier for you to make a decision for another application that is commercial in nature when you already have a commercial property that exists in that location, versus one where there is a stipulation of the zoning that it's residential in nature? I'll let you think about that. Thank you.
Ponder that.
Good afternoon. My name is Bob Hansman, 809 Greenbrier Drive. About all I do spend my time now is volunteering, and I've been associated with hospice since my wife passed away about 4 years ago, and I don't think any of you have any qualms about how good and what good that hospice does for the general area here. But I had never faced death before in my life until my wife passed away. And they were so helpful. She unexpectedly died there, and I couldn't have handled it myself. It meant that I didn't have to go home to the bedroom where she had laid for a number of times, months. But I feel, I don't want to lose hospice. And yet I understand no business, I've been in business myself, no business can sustain the kind of losses that the hospital has taken at hospice. I know they've cut it to the bone. I remember several years ago when they reduced staff. I don't think there's any more reduction in staff they could make. And I would hope that, I see no problem. I have a little bit of doubt about Victoria Heights. I've driven up there several times. I don't live there, but it seems to be a stretch that Victoria Heights are going to be concerned about the value of their properties. I don't know if you can even see them from where they live, but again, I don't live there. I just drove around to see how much they could see. But I would hope that you would reconsider and pass this so that the city commission can take a look at it again. I think they would be very fine combining the two of them, and that we wouldn't have to risk the chance of losing hospice. Yeah.
I've been concerned, one of the things we're supposed to worry about is the effect on the immediate neighbors. If you have a lot of people coming and going for meetings with counselors in the same building, nothing between you but the doorway between that kind of common area of the hospice proper and this office suite that will be the counseling center, how does that affect the families in the hospice? Is that really going to be compatible, or do you see that there'd be any kind of a conflict there of just the personal traffic in the building and the noise that it may generate, that sort of thing, compared to hospice as a freestanding operation? The way
personally, I don't see any problem at all. I mean, I realize it's a place where people go for the ending of their life. It'll be very separated. There's good sound barriers between it. And I don't think, if it was me, and it was me again, and Viridian was there, I would not hesitate to use hospice. I don't think it would affect the Viridian and hospice would be affected. I think they can live jointly together.
I only ask that because just 4 hours before this meeting, I had a recent hospice client say exactly the opposite. She said it would not have been as good an experience if there had been a lot more people coming and going in the building. But then, you know, that's also based on speculation. So I guess I'm at the point now where we've heard all these things about 6 or 7 times, and I'm still right on the midpoint of which way to go with this thing. It does, on the face of it, seem to me that it would be a conflicting interest in that close of proximity. But the other thing that's troubling, and I thank you for your comments, goes back to Mr. Hindenkamp's letter and his presentation. I don't know if we should go ahead and go to this degree of discussion now or not, but
well, let's finish the public portion.
I do have one more question for Mr. Hindenkamp.
Well, I'm only stating my opinion. I'm sure, you know, someone may have a different opinion, but I'm just stating how I felt about it.
Thank you very much.
Thank you.
I appreciate it.
Thank you.
Well, along those lines, is the director of the hospice here? Did I hear that was correct? Could you answer that question?
My name is Benny Salkill. I am the Director of Hospice at 730 Holly Lane here in Salina, Kansas. I think that Viridian would be a good partner for us. I don't think that there would be any problem because they're going to be confined to one side. We currently have people going in and out of that same area today. We have not only visitors that come out and go into that area, we also have employees that work out of that side of the building. It doesn't create a problem for the other side because we have the separation of the wall and the doorway. And when Veridian occupies that, that doorway will be locked, and Veridian will not be bringing their people into the common area. That is strictly going to be for hospice. So I don't see it as being a problem at all.
Is there any sound issues or anything like that that might come up?
I haven't observed any. I have more problem if we have the door open. With my office sits right there at the corner by the common area, and if my door's open and the door between the sides is open, I have more of a problem when I'm on the phone with people being out in the common area making noise. So I have to get up and shut either my door or the door out into the common area to reduce the noise in my office.
Just for everybody's benefit, John, could you put up the floor plan of the first floor, and could you point out to us when you're referring to common area, what area you're speaking to?
This would be the common area here.
So you're saying that the Veridian patients and staff won't have access to that area?
They won't be coming into it. Any other questions? Thank you. Thank you very much.
Thank you. Other remarks?
My name's Lance Billings. I live at 714 Victoria Heights Terrace. One of the questions that was just asked of Mr. MacArthur was if his property was up for sale, would he sell it, or has he had that opportunity? Our family's in the process probably about a year and a half out from building a home out in the country, and I might be putting my home up for sale up there. The back of my house does overlook the hospice facility. So I do have some concern about the property value when I do go put this house on the market. And does it help me determine, do I do the house out in the country or not? I have some concern about that, so that's why I'm here today and wanted to voice my thought on that. Another thought that came to my mind while I was listening to the individual speak back here from the hospital was, when this facility was built, it seems that as a business person, you're going to have a better forecast of what's going to be your profitability, or what's going to be your cost in doing a facility like this. And it perplexes me to think that you can lose $2.7 million and not have a better forecast as a business community. And so I think about the coming future, if they move the Veridian in, where does Veridian get their funding as far as the patients? Who provides the cost for the services? And if these services could be cut, what's going to be next for this facility and what would be next on the plate? So I think that might need to be taken into consideration in some of the thought process here. That's all I had for today. Thank you.
Anyone else, please? Well, if there are no others, I'll close the public portion of this item, and we'll bring it back to the commission for discussion. Gentlemen, do you have remarks or questions of staff?
I have a question for Mr. Stack. Does the traffic at all, the possible increase, concern you at all? What's your thoughts?
No, it's, as Mr. Hennekamp discussed, it's not more than a normal residential street, not more than any kind of entrance that we have on Crawford. We did check for Mr. Kearney the accidents, and there are some accidents in the area. Most of them are rear-end accidents on Crawford for somebody waiting to turn. Most are on Upper Mill Heights. There's only one rear end on Holly Lane and one rear end on Victoria Heights. So Holly Lane seems to be a function of traffic would not be very much. Upper Mill Heights carries more traffic, it looks like. Victoria Heights and Hollywood might be more similar, so we wouldn't see any reason to believe this would cause any more traffic accident concerns that are currently there today. And traffic designed for a typical entrance on an arterial like this is just, it's not a high-volume road that would necessitate any kind of traffic signal or any kind of warrants for concerns. For Marty.
Thank you. Mr. Stacken, either I've not understood properly, but my original notes from this was that there were 60 to 80 additional traffic counts that will be added if this would go through. Is that a correct statement, or I've heard conflicting comments now related to the number of traffic counts in a typical residential area?
Well, it's 110 pages, so I was trying to figure out where is the final number. What is the actual number?
I can speak to that a little bit. What we're trying to point out, and what Mr. Henenkamp's testimony was, the information he was provided by city staff, that a typical residential street that's all housing on it would carry from 100 to 300 cars a day. And this stretch of Holly Lane, with the hospice and the limited capacity that it's at, is well below that. So if you add 60 to 80 cars a day to Holly Lane, it's going to be quite noticeable. It's going to be a noticeable increase in traffic. However, adding that many trips a day on a street that has so little traffic to begin with is not going to put it in a category where it's unusual compared to other residential streets. When we go back to the original consideration of the hospice case, the original platting for the west side of Holly Lane had 14 single-family dwellings, and if you assume, which the trip generation per single-family dwelling is approximately 10 vehicle trips per day in and out, that would be 140 trips a day that would be generated by 14 new homes. So part of the difficulty here is that Holly Lane is so lightly traveled today that any increase of 60 to 80 cars a day is going to seem like a dramatic increase because it's not a busy street at all today. But if you compared that to a typical residential street that's lined with homes, those streets carry from 100 to 300 trips in a given day anyway. But Holly Lane is a cul-de-sac, it has one house on it and a hospice, and it carries very little traffic. But it is our projection, looking at the floor plan, the offices, the clinical space, that compared to what is happening with 12 hospice beds today, that there would be 60 to 80 additional trips going in and out as a result of Viridian's relocation that's not occurring today. That's our best projection.
Is there any way to compare that to if hospice was at full capacity, whatever full capacity might be? The original plan was for 26,000 square feet, 24-bed facility. That has never been realized, I don't believe. Well, the 26,000 has not been realized. It's only a 16,000-foot facility currently. But if that, as approved, is there any idea what the count would be at that point? Or is that pure speculation?
I think you'd have to basically take what's being observed today and double it. If part of the problem is, even though it has 12 beds today, the 12 beds are highly underutilized. It's not functioning as a 12-bed, 16,000 square foot facility. It's underutilized, so the parking load, the traffic load that's occurring today is well below even what was projected in 2004.
But if I'm getting Mr. Birdsong correctly, that if it was built out to the 26,000 square feet, is there a number that would the traffic count would go up to, say, 260 cars a day? Is that a fair number?
Dean, have you checked the ITE trip generation projection?
Yeah, the number that was used was the number for nursing homes, but I'd have to go back and look. The comparison that was done in 2004 for a 24-bed, $26,000 or 26,000 square foot facility was comparing that with 14 single-family units, and not to mention that there are 10 lots on the east side of Holly Lane that have not been built either. So if you had 19, it'll actually be 23 homes built on Holly Lane, then you would be generating 230 vehicle trips a day. And the conclusion was that a 26,000 square foot, 24-bed hospice facility would be equivalent to, but generate no more traffic than if you had full build-out of 23 homes. Because the original platting arrangement, there were 14, there was a cul-de-sac here, and there was 14 lots arrayed along here. And over here, we have all these lots here, and only one of them has a house on it. So if you had a house, this house, and a house, and perhaps another house here, align that there, then you're talking about 230 vehicle trips a day if it was just single family.
Yeah, I would suggest that in a community like Salina, we often allow development to occur, and we don't spend nearly this much time talking about traffic on streets that are purposely designed to handle traffic, which this appears to be. For example, Cloud Street is a mixed-use street. It has residential as well as commercial, and the residential is towards the end of Cloud Street. We just recently allowed Dillon's to build there. And I would assume that the traffic counts on Cloud Street are going to be far greater in any case than this will ever be. And in my opinion, that extension of Cloud Street nowhere mirrors the condition of this particular street. So, I'm a little concerned about the concern. And if we address this concern on traffic on Holly Lane to this extent in the future, we're going to have to address this each time someone comes and wants to build on that property. We have to talk about, is traffic appropriate? Truly, if traffic becomes an issue where Holly Lane enters onto Crawford, which, by the way, there's a bigger problem than that at the current ballpark, which needs to be considered because of the amount of traffic that turns on there after games and so forth, I assume traffic control devices would be merited at some point, wouldn't they, Dan?
That's been looked at many times, and they
It's
never
not-
have been.
it's not necessarily yet, but...
Well, it's just a function of the different warrants for a signal, and that one just, it doesn't meet it. It's surprising, I agree, I spend a lot of time there, but there are certain, very few times it doesn't meet it enough to warrant a signal, so that's...
You're talking about Holly?
What's that?
Holly?
Holly would not even...
Not even come close,
Not even
right.
close.
So the traffic is not a factor, you have to even warrant consideration of traffic control.
Well, I agree with Mr. Kennedy. I think that the traffic consideration is not paramount in my mind. But and I've listened to all these arguments. I was not at the first two meetings where this was discussed, and so I did miss on some of that stuff. But probably the good thing about that is I didn't get anything but a staff report, and I read those comments, and they were all very powerful. But to me, it comes back to a basic premise. What are the people on Victoria Heights going to look down and see? They're not going to look down and see hardly anything different than what's there already. And I go back to the blood platelet center at, Kent, help me out, Prescott. Yeah, that we did over there. That was right, it butted up to a historic district, and the neighbors were concerned about how it was going to look, and what kind of neighbors that the hospital was going to be, and about people hanging around and where they would park and stuff like that. And I got to tell you, Warren Ediger did a great job of designing that place, and the hospital has been nothing from what I can see other than a good neighbor there. We haven't had any complaints about that facility, and certainly they have demonstrated that they can live within a set of parameters and are good neighbors in the community. And I, for one, think that we need to reconsider this as for passage.
Gentlemen, I think it is time to move this along. If any of you have further questions that you need to have answered, or put them out there, please. But if there be none, the chairman will accept a motion to advance this in the affirmative with whatever conditions that the motion maker would like to do.
Well, I made the motion previous to advance this for approval, and I would be willing to do that again. Similar motion, that I would make the motion that we approve the application as presented before us with conditions as outlined previously, 1, 2, 3, and 5, excluding the condition that was previously put on, which was the primary entrance to be on the north side of the building. I think we've heard that that's not necessary nor needed nor would be appropriate at this time. So the conditions would be permitted conditional use of Lot 1. Block 1 shall include the hospice center and behavioral therapy offices and clinical space. No changes to the existing square footage of the blueprint shall be permitted. No changes to residential design or appearance to the exterior building materials or existing hospice facility shall be permitted, and use of the hospice facility shall substantially conform to the final site development plan, landscape plan, and lighting plan approved by the City Commission March 22nd, 2004, with the exception of the revised parking plan and signage plan presented by the City Salina Regional Health Center. And then there were 3 additional conditions that I think hospice agreed to, or that Salina Regional Medical Center agreed to, and that was hours to be 8 to 8, and we talked about square footage to remain, and then a smoking enclosure constructed if deemed necessary. With that, I would make a motion that we approve this application.
I'd second that motion.
There's a motion and a second. Is there further discussion? I'd like to make 2 remarks. I think this is probably the moment to convince other commissioners that may not be feeling in the same side of the matter as the motion has been made, but it seems to me this area would have been a slough and would continue to be a slough if a lot of good people hadn't put, a lot of important and prominent people in Salina hadn't put together money for the dream that hospice was. And I know that hasn't worked out so well, but that still doesn't mean we shouldn't try to preserve that vision. And number 2, I know we can't all make everybody happy here, but I think what the commissioners need to remember is to do what's right for Salina, and I believe that this Meriden group merged with hospice is a good match and a great piece of infill development in Salina. It's conditional use, it's just right here, it's not on everybody's corner, so please do what's right for Salina. We'll call the question. All those in favor say aye. Aye. Any opposed?
Nay.
Nay.
We'll record the vote as...
Do we have a show of hands, please?
Okay. All those in
Those in
favor?
favor of the motion?
And those opposed? Thank you very much. And thank you all out there for your generous time and your effort in this on this issue. Thank you. We'll move on to the next item. Excuse my voice, I'm pretty scratchy today. Number 3, application Z12-7, Kansas Wesleyan, requesting a review of the current prohibition on advertising signs in the U District.
Thank you, Mr. Chairman. There's a couple of things that we will start out with in your packet. Basically, this application presents 3 questions for you, which are policy questions. 1, advertising signs, which would be more familiar to you as off-premise advertising signs or billboards, are not presently allowed in university districts. Secondly, If you felt that in some circumstances they should be, then a second question would be how loud or how large those signs should be allowed to be. And then a third question that we thought was timely and should be brought up given our discussions on the public use district is in the future, as Kansas Wesleyan and other facilities look to the future, should the same provisions that deal with electronic changeable copy signs also be allowed in the university district. And in your packet, there is a summary of existing billboard regulations. And presently, billboard are allowed in the agricultural district, which we have some out along I-135 and I-70. You'll note in there that the maximum gross surface area for a billboard sign along the interstate is 400 square feet. Presently in residential public use, university, hospital medical, C1, C2, C3, C4 should be in there, and I-1, these types of signs are not permitted. C5, C6, and C7 allow them with the size of the sign permitted based on the square footage, based on the lineal foot of street frontage on the parcel they sit on. In I-2 and I-3, billboards are also allowed. What we have here presently is some of you who have been around for a while know that there was a sign up on the back of the scoreboard at Glenn Martin Stadium previously. That was put up there without going through this process of having the discussion and debate about whether advertising signs should be permitted in a university district. So basically there was a consent agreement entered into between the city manager and the president of Kansas Wesleyan University that allowed the sign to stay up there during the life of the existing leases, and there was an agreement that the signs would be removed after the leases expired, and they have all been removed. So now we are back with the blank side of a scoreboard. To put up a scoreboard at Dean Evans Stadium or Salina Stadium or Glenn Martin Stadium does not require a permit, and a scoreboard is not considered to be a sign. And if a Dean Evans Stadium or the Salina Bicentennial Center or Salina Stadium or Glenn Martin Stadium, there is internal logo signage or advertising on the scoreboard or in the stadium that's oriented towards those in attendance at the stadium, those are not considered signs. And so what we are talking about is considered to be an advertising sign because it has nothing to do with the scoreboard other than the fact that the scoreboard is serving as the support structure for a billboard or advertising sign. So the fact that it is a scoreboard is somewhat irrelevant in this case, other than that serves as a support structure for the proposed signage. So the first question is, should the sign regulations for the university district be amended to allow for advertising signs which are currently not listed among those uses? And John, I have in the packet a one-page sheet that says advertising signs in the university district. And so just to clarify, in terms of a text amendment, where looking at the structure of the sign regulations, what we would be looking at. We started out with saying these are the functional types that are permitted, and the most common signs that we have for a university or a school or any facility like that would be identification signs. And so identification signs are going to identify the facility and tell people with as multiple buildings what the name or function of that is. What is missing from this list is advertising signs. So this section would have to be amended to add advertising signs there. And then what we're suggesting is that it, and what Kansas Wesleyan basically has applied for, would not be to have a blanket permitted ability to have a billboard or advertising sign in university districts, but that it only be done through a conditional use permit process with notification, public hearing, and review on a case-by-case basis by the Planning Commission. So structurally, you would have to amend that. The other things that we saw as we walked through this is today, if Kansas Wesleyan wanted to put up a sign along Cloud Street that said Glenn Martin Stadium, that sign would be limited to no more than 160 square feet. And the sign that they have presently is located within 50 feet of the stadium. The other thing that we looked at is the regulations presently allow universities to have signs no taller than 10 feet. And then on the setback side of things, a sign larger than 32 square feet has to be maintain the same setback as principal structures in a university district. In a university district, that is 50 feet. And then only signs which are illuminated by reflected light from a source not contained within the sign itself should be permitted. Well, if we were going to talk about giving them the same ability to have the electronic changeable copy signs that was discussed in the public use district, then we would throw all that out and substitute what was recently done in the public use district. So as we walked through this, we realized that it was not a simple matter of just going up to the top and saying, well, we'll amend this section and we'll just add the word advertising signs and make it approved through a conditional use, and perhaps require that it be, if you had such a sign, it could only be allowed if it was located on our arterial street. So if we were just in a vacuum and we were drafting a text amendment for advertising signs beyond what we have today, we would not draft it of a size or magnitude of what we're talking about in terms of this specific request. So instead of attempting to draft an amendment, every time we looked at something, there was another thing based on what is out there existing today that doesn't fit one of the sections there. So if we walk, if you go back to the top, John, here, to accommodate this particular situation or request, these types of signs, off-premise or billboard signs, are not permitted today. This section would have to be amended to add that and qualifying language that it be allowed through a conditional use permit. If you could scroll up, John. This says for outdoor stadiums not to exceed 160 square feet each. The existing proposal that's in front of you today is for 576 square feet. And so, again, if we were drafting something, that 576 square feet even exceeds the 400 square feet, which is the maximum size you could have out along the interstate. And then the current height limit is 10 feet, and the existing scoreboard support structure is 26 feet tall, and the current setback requirement for a new sign would be 50 feet, and the current structure there is 40 feet from Cloud Street. So on the one hand, you've got a very specific request and a very specific location that you're looking at, but what we tried to do was itemize what would have to be changed to accommodate that, and then you've got to look at that across the board in the University District, recognizing that Kansas Wesleyan University, K-State Salina, the Marymount College campus where the Highway Patrol and the Administration Building are located, and St. John's Military School campus are all also zoned university. So I think the best thing to do is to walk through these one by one and to look at, they're presently, this is not allowed today. If you were to make an amendment to allow for them, and allow for them even, would you do it as a permitted or conditional use? Would you limit it to arterial streets only? It would be the first question. The second question to walk through would be, if you were going to make an allowance for off-premise advertising signs, would you entertain or support an amendment that allowed an individual sign to be 576 square feet? If you amend the height limit of signs in the University District, then you're more or less doing it across the board, unless you carve in an exception here that says that the limit's 10 feet except for advertising signs, which may be X number of feet, could be 30 or whatever you came up with, and then you would have to amend that. So just to tell you where staff was with this, our thought and our encouragement as Kansas Wesleyan looked long-term towards perhaps stadium or facility renovations, and John, I think you have in your packet, and John would have the ability to display kind of a conceptual plan for updating, upgrading the football stadium and adding a soccer facility to the east of that. We said that we would be glad and supportive of looking at doing some of the same sorts of things with the electronic changeable copy signs in a university district that we had with the public use district, and we discussed with our elementary and secondary schools. That made a lot of sense, but their request was that they had immediate desire and need to reinstate these signs on the back of the existing scoreboard there. And so the avenue for doing that is a request first to amend the text of the University District sign regulations to allow for that in the first place, and then amending them further to establish the limits, so to speak, of where, how big, how tall advertising signs could be. So these two are joined together. So as we look to the immediate upcoming fall season or school season or whatever you want, there's immediate request to modify this to turn it into a advertising sign, and then the ordinance has to be amended to allow that, and then on the hope and anticipation that you would view that favorably, then there was a companion conditional use permit request for the specific sign in the specific location, which was helpful to staff because it allowed us to walk through what the existing circumstances were. So what I can say is that if we were working on our own in a vacuum and just coming up with a set of guidelines, I don't think we'd have come up with 576 square feet as a sign size. But it's the first step is to see whether a majority of planning commissioners are supportive of going there first, of allowing advertising signs at all. Again, as we look to long-term and a stadium renovation there, then having the kind of electronic changeable copy sign that we talked about at Salina Stadium and Dean Evans Stadium or places like that that would be changeable copy and have upcoming events or game times or things like that make perfect sense. But this is an immediate desire on the part of Kansas Wesleyan to do something in what I would call a static billboard in the meantime. So that is our best job of explaining it from our perspective, and I think we would just start out with any questions you have about advertising signs, billboards, the current regulatory structure that we have.
I didn't see anything in there that addressed scoreboards specifically. I mean, could they just have a conditional use for a scoreboard and then address scoreboards in the U?
Well, you do. The scoreboards do not require a sign permit or any type of permit. They don't need any approval to have a scoreboard, and they don't need any approval if you flipped this. This is not a sign or a regulated sign because it's not oriented outwards towards the public street or the public. So school district, city of Salina, nobody needs any regulatory approval to put that type of logo or advertisement inside a stadium because it's oriented to those in attendance at the stadium. What happens is, as soon as you go outside the stadium, then this ceases to be a scoreboard and it's simply a support structure for a billboard or advertising sign.
So I guess what I'm thinking is the language would need to address what's not thought about. I mean, you can have yourself a scoreboard, but the reverse side of the scoreboard is considered a billboard, and then if they want to use it as a billboard, have some conditional requirements.
I think that in even a bigger scope, let's say the school district wanted to put up a new stadium and they wanted to have naming rights for the stadium. And at some point they could sell off the back side of that, something that faces outward of the stadium and was not meant for the people inside the venue. They could sell that to, say, let's say Phillips, for example. And so this would fall under that kind of a guideline, something that was outside of the view of the people.
Well, if you have a sign on this and all the sign says is Glenn Martin Stadium, that is an identification sign. That is not an advertising sign. It's not a billboard. What we're talking about here, an advertising sign is a sign that advertises a product or service or business that has no relationship to this location. So that is different than a identification sign.
Couldn't we make this easy and just leave it exactly the way it is? You can put in parentheses on each one of them, like on 4, 5, 6, and 7. Any additional square footage shall be a conditional use permit. I mean, every one of those could be put that way. If you're talking about an advertising sign, it'd need to be applied for through the conditional use permit process. In the event you wanted more than 6 lineal feet, please fill out additional thing. I mean, I think it's going to be a case-by-case basis. I would hate to add 596 square feet as our basis and then have somebody come up that doesn't fit in there, knowing in advance what's coming behind this motion. I don't want to put something in there that says I'm okay with 600 square feet. I'm not okay with saying 400 square feet because now all of a sudden we're going to make a motion that doesn't approve what's behind there, and what's going on behind this was there at one time, and it wasn't offensive to me. So
does 596 square feet sounds like a lot, or whatever they're asking for, but then the other thing I would talk about is, we also could be sitting here going, why is Kansas Wesleyan not taking pride in their scoreboard behind it? Well, they don't have to. I mean, there also could be rust and things forming behind this that now faces outwards. I think they've done a nice job protecting that, or any scoreboard in general.
And that's my point exactly, too, is that let's use the school example in Phillips Lighting again. They build a 10,000-seat stadium. Phillips Lighting is going to want their name pretty big on that thing. If you put a 576 square foot sign on the Intrust Bank Center, it's going to look like a postage stamp. I think that they all need to be conditional use over a certain size, and I'm totally for going ahead with the advertising signs.
I have a question. We're going to get bogged down in here in language and zoning regulation changes and code change. Can we act on this individually? I mean, as a commission, can we make a recommendation, just merely act on a conditional use to allow advertising sign on this particular site, this time, and leave the others out of the picture for this time? I don't want to get, if we start talking about changing zoning regulation, we'll be here next year talking about it yet. Can we do that? Are we within our right? No. So we have to change the university zoning conditions for everyone before we can even act on this.
That is correct, because
that's a whole different
Kansas Wesleyan University does not have standing to even apply for a conditional use permit for an advertising sign unless you are supportive of an amendment to the university district sign regulations to allow advertising signs in the first place. You cannot apply for a conditional use permit for something that's not allowed.
But why couldn't we at the very bottom of all of this just say, unless you're applying for a conditional use permit?
I agree. Make it simple.
It's like
Well, and then you bring it back and better repaired for us.
How many-
to consider another day.
How many districts do we even allow off-site advertising signs? Very few.
Well, we walk that in the agricultural district, which much of our land out along I-70 and I-135 is agricultural. And in C5, C6, and C7, which tend to be out by the interstate, and I-2 and I-3. All of the remaining districts do not allow advertising signs, which again is off, billboards are off.
And the P classification was...
The big white pen was not particularly attractive, but I don't like the idea of having 600 square feet of off-site positive reinforcement of a variety of businesses that aren't related to a specific project activity on that college campus. I sure like the idea of the schools being able to have signs, and even the moving signs, that talk at least primarily about what's going on at that school. But just to have a general off-site advertising program on Cloud Street, which from there for quite a few blocks is essentially residential, I just...
Well, how much of the advertising on the bicentennial sign is for the...
I don't like that either. I didn't get to go down that far. I don't like that either.
But you know, if you look, sometimes you sort of have to look at things of what's better for the community. My personal opinion, I go by there a lot, the white painted back of that particular sign looks terrible right now. Now, there are options. We could turn into an outdoor movie theater, and they could park in the lot across at St. Mary's, and upstairs we compete with Wilson that way. But that's not really an option we're going to look at here. And before, I don't really remember it being offensive or even noticeable when they had the advertising signs on it. It just didn't stand out. Then they went and painted it white, and it stands out like a sore thumb.
I do believe it would be harder for me to be excited about it had I not already seen it, but it was already there for a year or 2 years or something, and I just didn't even notice it.
I didn't either,
The landscape that was there, but now the white sign you notice more so.
Looks like
It's certainly not out of character to associate a sporting event with advertisement. That happens like in every venue that you can think of. And people, alumni, want to align themselves with their hometown team.
And we see this differently than if we said, take every one of those little things that they cut and pasted on there, and I understand that's just a what if. I don't know that they've sold all that. But if we took every one of those little signs and put it on a post and put it along the street there, would we be in favor of that?
No.
If we took all those little signs and put every one of them on a post and lined them up down Cloud, would we be okay with that?
Well, it's different. That's different than what we're requesting here, though. I think it's different. It's not about the advertising, it's about this particular, my point is it's about this particular feature at this particular location. Given my choice, I'd rather see the whole scoreboard on the other end of the stadium, but it's not. It happens to be here. There's a sign, I think, bigger than this down by Snow Wizard. If you look at that, it's got some picture of some gentleman on it, and it's a huge billboard sign as you're coming up Ohio from the south and north. I assume that's approved in that district, I don't know, but it's huge. I never noticed it till the other day.
Some is behind Brahms, so those are billboards behind Brahms and then down by the Snow Wizard.
And we added that note at the end of your report that it should be noted there are several billboards located throughout the city that are legal non-conforming signs and may not comply with one or more of the existing regulations based on when they were installed. But those can remain as billboards for as long as they continue to be used billboards. John, if you could back up to the advertising signs in the U District form, I'll take a crack at something that could be somewhat simplified and would be potentially permissible. And that you could take something along these lines and then you could maintain this limitation and you could go in here and insert except for advertising signs approved under a conditional use permit by the Planning Commission. You would maintain the 10-foot height except for advertising signs approved under a conditional use permit by the Planning Commission. And you could go back and do a qualification of
That's what you
these.
said. I believe you're right. Todd likes that idea. I think I heard it. So would we need a motion to do that then? Is that what happens and the city commission has to approve it?
What you would need to do is to go through and answer our questions one by one and direct us accordingly. Are you receptive to allowing advertising signs in the University District on a case-by-case basis under a conditional use permit?
Yes. Yes.
Yeah, you want that as consensus or a?
I'd prefer that there be a motion on each of those.
I'd make a motion that we approve adding advertising signs as a conditional use permit.
Second. All those in favor?
Aye.
Any opposed? Next question.
And the next question is, if so, how large should the advertising signs be? And what I'm hearing is, rather than trying to come up with a cap or a number, that you leave the 160 square feet in place, but you add language that says, except for advertising signs approved under a conditional use permit, which would allow you to judge that on a case-by-case basis.
You just said it.
I would make a motion that we allow standard 160 square feet, except by case-by-case basis, approved by the planning department, or planning commission, under conditional use.
I believe Mr. Kennedy just made that motion, but...
Well, I'm sorry.
I'll just second Todd's. Since he went to all the words of putting them, I'll second that.
You've heard the motion and the second. Is there any discussion? All those in favor say aye.
Aye.
Any opposed? And there was a third question?
The third question is, while we're talking about University District regulations and all of the discussions we've had with the Public Use District and others, all of this language we have in here about illumination in a lot of our districts is really antiquated and not very helpful. Is the Commission supportive of going back and looking, as we look long-term, to adopting something similar on the electronic changeable copy signs that you recently approved for the Public Use District? So if you envision a redone Glenn Martin Stadium, and could you be supportive of having an electronic changeable copy sign out on Cloud Street? And do you want us, to, as we're looking at this, to address that?
Commissioners, are there any of you that are not agreeable to that? And I think we have a consensus on that item too.
Before we have any action that would, you've given us the parameters of that. So now what we've basically done is clarify a proposed text amendment to the university sign regulations. And that text amendment, under your direction, would be to allow for advertising signs as a conditional use, allow exceptions to the 160-foot cap if approved under a conditional use permit by the Planning Commission. And you've also asked us to look at taking this language here and doing something along the lines of the public use district. At this point, this is an advertised public hearing on a text amendment, and we would want to hear from representatives of Kansas Wesleyan University whether they have questions about the parameters of that and any other interested members of the public that would like to speak to that.
Okay. If we're done with the staff portion, are there, would Wesleyan like to address the commission, please?
I don't think I could come up with any more detail than Dean already has, but the basic reason for this, obviously, is an opportunity for revenue for the university. Without having that advertising, that has cut back significantly revenue that we had used for our athletic programs and other programs on campus. And so this would allow us to then utilize that sign until the sign comes down, if it comes down in a future project, for us to have outside advertising on there. We don't have commitments from anyone. We do have several people who said if that were to open up again, that they would be very interested. And the average revenue is somewhere between $7,500 and $20,000 a year, depending on how we work the structure of the contracts.
The parameters that were discussed, obviously we have a companion conditional use for the specific sign, but the parameters discussed of, I would presume you don't have any objections to creating a conditional use process for this sign or any future advertising signs, and having an exception to the 160-foot cap on the maximum size if it's approved under a conditional use permit. And do you have any thoughts about your desire long-term to be able to have electronic changeable copy signs?
The first question is no, we'd be pleased to do so and would follow that appropriately. Second question about our future for electronic signs. We own quite a bit of property around the campus, and we have master plans for future development of campus housing, et cetera, if the university grows and that becomes appropriate. Were we to have a sign such as that, it probably wouldn't be located on Cloud Street. It would probably be located on 9th Street, where we have property ownership, where it would make more sense and be on a higher traffic area. But that is not, at this point, we would adhere to whatever the law says, but we don't have a future design for an electronic billboard on Cloud Street at this time, or thought in our master plan.
But given that basically the current regulations don't allow for any type of illuminated sign, you'd be interested in removing that restriction and being able to have electronic changeable copy based on the changes.
That's correct.
Future technology.
That's correct.
Dean, their conditional use permit wouldn't be tied to any specific copy, would it? In other words, like if they want to change advertisers or something, they wouldn't have, it's more tied to the square footage.
No, it would establish the parameters of the height, the square footage. You can't regulate content. So if a business changed hands or whatever and they changed it out, we don't even require permits for a face change. What the conditional use permit would establish: the location, the height, the maximum square footage, and that not the content. And the fact that these are advertisers who are not located at that location on Cloud Street.
I don't know when the last review of the U category's been, but obviously some of this is antiquated. You may want to work with the city staff as they go through the process of revamping some of these things. I think it's pretty obvious we're going to just have big screen TV monitors wherever we want to have signage, and so it's not right here in Salina, Kansas yet, but it's a lot of places. So you may want to look into your future. And
when they did the new Student Activities Center there at 4th and Claflin, there was some discussion then about, and discussions with Wayne Schneider at Kansas Wesleyan about doing some of this that would allow even perhaps something like that over by the Student Activities Center, but there was nothing initiated at that time by Kansas Wesleyan, and since we're now looking at all of the sign regulations applicable to University District, this would be the time to address it.
any questions or for Mr. Chapman, or any more comments? Thank you. Would the public like to address this issue? Anyone in the gallery? There being none, we'll bring it back to the commission. Dean, do you have what you need on this item, or do we need another motion?
We have three separate motions, and again, to summarize, a specific amendment to allow advertising signs as a conditional use, to modify the limitations on height, setback, and square footage, to create an exception for advertising signs that are approved under a conditional use permit, and to come back with some language for yourselves and Kansas Wesleyan to look at in terms of the ability to have electronic changeable copy signs.
Okay. We'll move on to number 4, application CU 12-6, also filed by Kansas Wesleyan, requesting approval of a conditional use permit for the advertising sign.
And we will clarify, this is also a public hearing item, and there was notice provided of this specific request, and that notice did go to St. Mary's Church and School. And if you'll recall back to earlier in the meeting, we had Father Kerry Ninemeyer, who responded to that by indicating to you that St. Mary's was not opposed to the proposal for the advertising sign, this particular specific request. So the other clarification I was make is that it helps for the discussion of these issues to know the parameters of what we're talking about, but when we're talking about amending the zoning text, you are making a recommendation that the City Commission is free to endorse or not endorse. And so in the context of this conditional use permit, you're hearing this because you had a favorable recommendation on allowing advertising signs, and this is the specific request. I think you're familiar with it. The signs would face outward towards Cloud Street, not inward towards the stadium, making it a billboard and no longer a scoreboard. We've determined it's set back 40 feet from the Cloud Street property line. It's 26 feet tall. The back of the scoreboard measures 16 by 36, which is 576 square feet. And Kansas Wesleyan is proposing to lease the entire square footage for advertising signs. Your role is to consider where the proposal that you have in front of them. In front of you would have an adverse effect on neighboring properties or the Cloud Street corridor as a whole. One of the things that we noted in our report is that the advertising sign is larger than the 160 square foot stadium identification sign allowed under the U District regulations. And so you have addressed that by recommending that an exception be allowed for advertising signs approved under a conditional use permit. Kansas Wesleyan believes that this would contribute to the welfare and convenience of the public by increasing public awareness of local restaurants and businesses that support KWU. The question for you is whether this is an appropriate location for such a increase in public awareness. This Cloud Street is an arterial street. There's no homes directly across the street. They're not proposing to increase the size of the existing scoreboard, but we pointed out it's quite large, 576 square feet. It could be perceived as dominating the streetscape on Cloud. There's no impact on public utilities or services. There's no impact on traffic access and parking. Again, any action that you would make on this is contingent on a text amendment actually being approved by the City Commission, saying they're willing to grant you that discretion. But your options would be to approve conditionally the application for an advertising sign, approve it subject to any specified conditions or revisions. In other words, you could require the size of the sign to be scaled down. You could postpone consideration if you think you need additional information, or you could deny the application if you think that would be an injury to surrounding properties if such a sign was approved in this location. And again, any effect or validity of a conditional use permit would be subject to an approved amendment to allow advertising signs in the first place.
Anybody know how long that sign's been there?
I know how long the sign that was formerly there was there for about 7 years.
Dean, is this, item number 4 that we're talking about now, is this a public hearing for that?
Yes, it is
Okay,
a
so we need to
public
have
hearing. We'd want to hear.
It seems like we've covered the basis of what we're looking at
But
here.
these are individual items. The text amendment is one item, and this particular request for this sign in this location, we sent notice out to property owners within 200 feet of Glenn Martin Stadium, and it's a public hearing for Kansas Wesleyans and other comment.
Okay. May we hear from the applicant? And I failed to say, you're supposed to state your name
Yeah, I
and
know.
address, and
I'm
just
Jeff
catch
Chapman,
that
I'm
up.
representing Kansas Wesleyan, 100 East Claflin. Thank you, Carl. If you don't remember me, I was just here recently. I was, again, it's basically about revenue for the university, an opportunity for us to increase incoming revenue for our budget to use for a variety of things at Kansas Wesleyan, and it's a significant amount compared to the size of our budget, so we're hopeful that this will be approved and that we can go forward and seek happy advertisers.
Any questions for Mr. Chapman?
Any stipulations that the campus has in general of what they want, since we can't predict what copy would be put on there, or we can't restrict it, is there any guidelines that the university has in place of what they will or will not allow to be put on the back of the billboard?
I can say that based on the nature of the university itself, that it will be fairly conservative. We typically just logos, no other messages. Does that answer what?
A little bit on there. I guess on there it's for, given the aspect across from the grade school that's there, if somebody who sold alcoholic beverages came there, is that something that the university would or wouldn't allow, do you think? I mean, I can't control it. I'm just asking questions to...
I don't believe that would be considered. I don't believe we'd consider that. I don't believe that would be... We wouldn't...
I don't mean to put you on the spot. I'm just...
No, I just don't believe that would be considered.
You're Methodist.
Yeah. Okay.
I do have one question for the commission, I guess indirectly, Mr. Chapman. When we were looking at conditions or stipulations, one thing that we discussed and considered was essentially the question of whether since it is a potentially a conditionally approved sign, whether there would be any support for saying that at such point in time that the stadium is renovated and an electronic message center sign was installed, that this sign would have to be removed at that point in time, or whether you want to have any kind of sunsetting or anything on this approval. Because absent that, then the sign is essentially approved in perpetuity. But we didn't know what the thoughts would be that if the stadium was updated and we got an electronic changeable copy sign that was installed for the stadium, should this be removed or should it remain in perpetuity?
I could go either way with
Well,
that.
I do too. I think you bring up a good point, Dean, on there. Is there a way that we could, and in helping you too in selling the advertisement on there, but in 5 years, I may look at that in the way that all redevelops with what's going on there. I may not be okay with that. Is there a stipulation that we could approve of this conditional use permit or allow that to have advertising on it for a 5-year period? And then they have to come back if they want to extend that?
Any conditional use permit can have a duration on it subject to being renewed if you so desire. So
The only reason I like that is if we approve it forever, then it stays there forever. I just wouldn't want, whether it be them or anybody who comes back with a conditional use before, to take advantage of that, to now have a new scoreboard, but then leave that in place only so that they can continue getting revenue. But now it doesn't even match the scope of what its intent was for.
Can I
So-
answer that, or am I?
Yeah, go ahead.
We don't have any intention on leaving that were we to renovate or make changes in that facility, but we would be comfortable with a time period of a certain number of years if that's the only way that you'll consider this. But our plans are, if we do make changes there, that we would have something different, and that would be removed anyway. That particular sign would be removed anyway.
I do like the concept of a time limit. It gives an opportunity for the community to see what's happening and for the future commissions to revisit this. Like I said, the back of a scoreboard, it's hard to make it look nice. It's just huge. And so I think the time limit would be appropriate.
Does Kansas West have a problem rejecting with a 5-year time limit?
I'd like to
or
request 7.
7 years?
Any other questions or comments for Mr. Chapman? Are there any others in the public that would like to address this issue? There being none, I'll close the public session and we'll bring it back to the commission. Gentlemen, are there further remarks or is there a motion on this item?
And
Don't everybody
the
jump up.
suggested language perhaps for a condition would be that the conditional use permit be approved subject to review and renewal of the permit in 7 years.
I'm sort of leaning towards the 5-year earliest. I think 5 years gives plenty of time. If it's successful, another 2 years seems like it would be easy to achieve, but I sort of think 5 years is quite a long time, and with your work in that area, you're probably going to be doing something, we hope, in that period of time. So I would make a motion that we approve the conditional use permits contingent upon city commission approval of the zoning changes and to include a condition of a 5-year limit on this permit.
I'll second that.
Been moved and seconded. Any other discussion? All in favor, say aye.
Aye.
Any opposed? The item carries. Thank you, Mr. Chapman. And I know it's been a long meeting, so we appreciate everybody's patience for enduring 3 hours. Wow. Item number 5. A hearing to determine whether the conditional use permit CU 11-8 for Smoky Auto Body should be revoked. So staff remarks.
Yes, Mr. Chairman, we scheduled this item before we knew that hospice was coming back onto your agenda, but nonetheless, at the direction of the Planning Commission, who is concerned that what they felt were conditions that were established at your October 4th, 2011 public hearing, allowing Smokey's Auto Body to establish and operate a body shop at the 900 North Santa Fe, that those conditions were not being enforced or adhered to. We set up this hearing basically to, one, go over those hearings, stipulations, two, tell you which ones have been complied with, and three, to lay out options for you to, one, either revoke the body shop's conditional use permit for failure to comply with the conditions of permit approval, or to look at those conditions individually or in total and either modify or strengthen or eliminate any of those original conditions and establish a deadline for compliance with those conditions. Or you can allow the business additional time to bring the operation of the body shop into compliance. But just in short summary, you approved the use but left it for staff and the applicant to get an administratively approved site plan that dealt with establishing parking areas, screening, and fenced areas. Nothing has occurred since the approval by the Planning Commission in October 2011. Not everything that has taken place up there has occurred either in the building or within a screened-in area. There has been no fence installed north of the building, as was discussed at the hearing. We've got, with the result of having no site plan, we don't have designated clearly striped stalls for customers and employees, and it's been our observation that not all vehicles have been parked or stored on the existing paved areas. So since the conditional use permit was approved, various members of Development Services staff and the fire department have observed things going on there that are not in compliance. And I guess our final point was that one of the follow-up items was submittal of a permit application and issuance of a permit for a installed paint booth inside the building to allow for body painting, and that permit has never been processed or issued at this point in time. So again, I would be happy to address any questions you have about the content of the staff report or the three alternatives that we've identified for you.
Any questions of staff? I just noticed one, just want to drive by there too. It seems like one other thing, I think that maybe the window, the panes on the window, there's some requirement about not exceeding a certain amount of space of signage on windows. Is that in compliance?
Mr. Burr could speak to that better, but there is supposed to be a limit on how much of a window a sign area can cover.
I'm certain in the C4 district that that's an allowance. I'd probably have to consult the ordinance to see if that applies to C5s.
May not. It's okay.
Yeah, there is a limitation in the downtown district. You can cover 33% of a window area to make it non-transparent, but we would have to follow up to see if that extends beyond the C4 district.
That's all right. I'm fine. May I hear from the applicant?
Yeah, my name's John Smokovich from when I did went through with the permits and stuff for the paint booth, I bought the Belvis paint booth. I went through it, had the manuals, everything. I hired the engineers, the city engineer. Everybody looked at it, approved it, and then it came before 5 committees. It got approved except for the last committee, and because I wasn't paved around the back and the side, which I have no idea what that has to do with my paint booth. But so I sold my paint booth to a business down the street because obviously it's not my property, and my landlord will not pave it or fence it in. I'm willing to do that to keep my business, to comply with everything that you want to do. I just need more time because I'm going to have to do it on my own. That's what I'm asking of you.
Dean, can you address that? Is that
You're leasing from Randy Pedersen, is that right?
Yes, sir.
what's the caveat about the paving having something to do with the paint booth permit?
No, the two are not related. The issuance of a building permit for a paint booth was simply a function of the information that was submitted with the permit application about the particular specifications of the paint booth. We indicated that we reported back on the review of that part of any building permit is a determination by planning staff that the site is in compliance with zoning requirements, and our report back on that permit application was that we couldn't report that it was in compliance because the stipulations that were on the conditional use permit had not been complied with. But that was part of our comments on the permit request. But that's not the sole reason why the paint booth permit was not issued. It was one of the items that needed to be addressed.
I'm sorry, but I missed your name, please. Your name, I'm sorry.
John Smokovich.
John, Mr. Slocovich. The real issue, I think, before us are what? The 5 conditions that have not been met.
Right.
That were part of the original conditional use permit. And I think the desire of a conditional use permit is you must meet those conditions. You haven't done it. Can you do it?
I can do it.
And how soon can you do it? It's been in operation now for quite a while, 10 months?
Well, it took almost 3 months to get the booth thing going.
Well, I'm not talking about the paint booth, I'm talking about the other.
And then what it ended up being was I couldn't do it anyway.
I'm talking about not the paint booth, no, I'm just talking about the other 5 aspects of the conditions that were originally imposed on this conditional use permit that you're out of compliance with. Parking on the grass, for example.
Everything that's on the grass right there, that one car that's on the grass, it would drives. There's no junk around the back of my thing. I don't keep parts out back, so if you want a fence up there, I'll put a fence up there, but nothing's going to be in it. I mean, I don't keep trash. I think my yard is cleaner than most of that neighborhood.
Well, I believe Dean mentioned site plan, no fence, no parking on the grass, vehicles on grass, no parking stalls identified by painting, and some other use, and I missed that one, it's in here. Can you come into compliance with all those things in a very short period of time and remain in compliance? That's really the question.
Well, I can do the only thing that's going to take time is getting that asphalt, because it said you can't have gravel, you know, he said it's got to be paved. That's the biggest thing that I'm going to have to do, because like I said, the landlord is not going to do it.
But I don't think, Dean, if I remember correctly from the conditional use permit, the only reason we asked him to concrete or asphalt back behind was because you were going to be storing either wrecked cars or prior to him being able to go inside and be worked on.
But I don't do that.
Okay, and so that's what
I mean, I understand that's why most body shops do that, you know, and keep them pinned up for safety too. But I'm a one-man operation, and if I schedule correctly, I keep one out front there, or maybe 2, and then I don't have anything out back.
Yeah, so I agree with you on there, but so that's what I'm trying to state is I don't know that you may want to reconsider, or maybe that isn't part of it, to build a 6-foot fence and the concrete all around it if you're not asking for that. I remember specifically us asking for, you said you would have cars being waiting to have work done to it, so there may be in a collision, they tow it down there, you're waiting to be done. We asked for that to be on concrete or hard asphalt and to be screened. And if you're telling me that you're not doing that type of work, then I would hate to have you spend $10,000 for concrete and a fence if there's nothing back there. I've personally driven by there and I've seen cars not parked on hard asphalt or concrete.
Oh, yeah, I know, that's true.
And that's where some of this became an issue, as well as then city staff and the fire department finding out about you painting cars down there and not having an approved paint booth. That's the reason that you're here, in my opinion.
Right.
So I guess what I'm asking for is if you want to have to ask the commission, if you can keep cars on a hard surface area and no junk around the building back behind, I'm not quite sure that I'm not going to ask you, I don't know about my fellow peers here, but I'm not going to ask you to put $10,000 worth of concrete and a $4,000 privacy fence up there if you're not going to store that. But that was your original request, correct? So you're out of violation because your original request was you were going to put a 6-foot privacy fence, but now you're telling me you don't really need that because you're not storing anything back there.
I didn't want the 6-foot fence. That was, well, I thought that was one of your requests.
Because you said you were going to have cars stacked up all around there waiting to go inside. You said you couldn't cover all of the cars that may be waiting for collision repair to be worked on. And we asked you, where would you put those? And you said, well, they would be around the building. And so we said,
on the side of the, because it's concreted around the front and the other side.
Okay.
Then there is 3 stalls on the.
right. So like that yellow car that's there, to me, I would not approve the conditional use permit if I knew you were going to stack 4 yellow cars that were waiting for repair and a blue Camaro on the grass. I wouldn't have approved it. But when you said that you would allow that type of activity to go on inside a screened area, then I was all for you to approve it. So I'm not sure either are going to have that stuff there and it can be screened, or you're not going to have that stuff there and you can comply with what originally was done.
Well, I can comply with that and get rid of those cars. I mean, that's not even, that's just somebody's, well, that's not my vehicle. That's not a customer vehicle either. That's someone I know's vehicle.
Okay.
That can be removed. So, I mean, the only other vehicle there that's a customer is that truck in front of the door. The rest of those, so.
If 2 cars came into you tomorrow and people wanted repaired,
Yeah.
where would you park those? If your 2 bays were completely full now with being body work and things done, where would you park those?
On the other side, where that Mustang is, on the other side. There's 3 stalls there that are paved before it goes into the grass.
Okay.
That's where I would put them.
And again, I didn't review the minutes on there, but I think that was my concern again, is that if something has been wrecked, and then now you're storing it on that side, you are on a hard surface, I agree with that, but now it's not screened.
That's
And-
okay.
And I think what we were trying to get you to do before was to
Just fence in that side.
fence in that side, is if
Okay.
there are any...
I can do that.
If there are any vehicles that were waiting for repair, that they would be behind on a hard surface.
So out of sight
screened.
of the public.
Yeah, and it sounds like maybe when you hit the meeting with Dean, is that the fire department, or they came down and said, is he in compliance with the conditional use permit to approve your paint booth? And they replied back and said, no, it's not in compliance because he didn't put up the fence and he doesn't have the concrete around back, so you didn't get approved for the paint booth, as well as maybe other various reasons for fire and ventilation, things like that. Does that make sense?
Sure.
There is a connection, but it's not the sole reason
Okay.
that the permit's not been issued.
I will fence off, privacy fence, a 6-foot area or big enough to park 2 cars in. I can do that over a paved area, so it is out of view on the public, the collision cars. You know, I'm not a big place, so it's only going to be a couple of stalls anyway. That I could do. The only thing that's going to be harder, take a little more time, like I said, is the concrete. Because it's not my property, and I have to do it just to stay in business, so. I mean, other than that, I can do the fence, no problem.
One of the purposes of zoning is to make our community look better.
Sure.
And then we set conditions here that we thought would allow you to have a business and make the area look better in the process, and we want that. And we want you to be successful. But you're out of compliance, and we can beat it to death all we want. I think staff understand the needs to bring it back into compliance. My question is, can you bring it back into compliance, and how quickly can you do that?
I need at least a month to pay for the concrete.
Well, you know, and we've allowed, in previous times, we've allowed people to have some time, but understand that if it's not brought back in compliance in that period of time, I'll be the first one to make the motion that we deny your permit.
I understand.
Because I mean, that's just the way I feel about it. So that's just my opinion.
Well, how long would you give me to do it?
You said you need 30 days, and it
At
seems to me
least, I
like
mean,
that's a little
minimum.
difficult to get accomplished,
Yeah.
but I would be...
The concrete guys are busy, I'm not
I know
pushing
they
the
are.
concrete guy down there in 30 days.
I think we've allowed more than that in a couple of cases, so it seems to me if you had 60 days to bring it into full compliance and 30 days to get the cars that are not operable removed or out of sight would be reasonable.
Sure. I have no problem.
That sound reasonable?
Sure, I'm willing to comply,
Until
absolutely.
November 1.
Number one, but the cars that are not operable need to be out of sight in 30 days, within 30 days. Is that would be my...
And/or screen back behind.
And a screen,
If he
yes.
gets in
Sure, in
compliance,
compliance,
it's
the screen is gonna be there.
Want back
Yeah.
there, as long as they're screened within that fence and gated.
Okay.
Does that need to be in form of motion then?
Yeah, what we had there for option 3 was allow the business additional time to bring the operation of the body shop into compliance with the conditions of approval. A motion would be in order to specify what amount of additional time you might be willing to grant, and then we would communicate that in writing to the applicant, to the owner, and would have that, so we'd have that documented if it needed to be brought back to you. It should be in the form of a motion to grant them additional time to bring the operation into compliance and your, whatever time periods you get the majority support of.
As a public hearing item, should we allow or offer the
This is a
opportunity
public
for...
hearing item, so anybody who's here wants to speak to this in addition to the Smokoviches should have that opportunity.
So Smokey, just let me say that. Is there anybody else in the room that would like to address this issue? Okay, thank you. Are there any other questions or
No, I mean,
questions for you or questions for us? I'll bring it back to the commission. Gentlemen?
I just ask that you'd give me a decent, like you said, the concrete guys are busy, if you can give me an adequate time, because I have a small place that I'm a problem.
November 1st, 60 days?
That'll work.
Okay.
What are you asking him to do?
To come into compliance with the violation city.
Which is?
Which are, let me find the list.
Site plan,
Site plans.
In other words, are we asking him to clean it up?
In of a sense.
That's really all we're asking.
Some of it.
Because we got concrete there.
Well, but if he's going to store, he can get rid of all the cars that he wants, but if he's going to store cars on the premises after hours, then it needs to be behind a fence, screened area, and on a hard surface area.
Perfect. The conditions are pretty clear, it's just a matter of coming into compliance with the conditions, which he's not at this point. I mean, they're already laid out, we approved this, they're fairly clear.
Right, they're clear.
They're clear, and you've agreed to.
Sure.
It should be rather simple for him to do what you ask him to do.
Sure.
Yeah.
I believe. Oh, you talking 3 months, 4 months? No, you don't need that long.
Well, I would say, Merle, that if I were to pour concrete tomorrow, it's very difficult to get a concrete gentleman there tomorrow, so 60 days would be great.
Okay.
And you probably have to work with your landlord a little bit on this.
I'm trying.
Bill, is there a motion on this item?
I would make a motion that we allow the business additional time to bring the operation of the body shop into compliance with the conditions as previously approved on the conditional use permit, to include 60 days of allowable time to bring it into compliance and 30 days of time to remove all non-operable vehicles from outdoor storage.
I'd second that.
Any other discussion? All those in favor say aye. Aye. Any opposed? Thank you very much, sir.
Thank you for your time.
Appreciate your patience.
Thanks.
Maybe the longest meeting we've ever had.
I'm working on it.
Item number 6, withdraw application Z12-2 and authorize staff to initiate new applications.
Okay, we're in favor of
Well,
that.
we've had discussion, debate, whether we put too much, not enough background information into your report, but from your perspective side, just wanted to outline that the comprehensive plan recommended the creation of a public use zoning district for the various civic and public uses we had around the community. After a lot of number of multiple hearings and reviews, there was a draft set of public use district regulations that were recommended for approval, and the City Commission concurred with, which created a new zoning district which was nowhere mapped in the community. And in addition, supplementary to that, there was a set of sign regulations that applied to public use zoning district that were approved by the City Commission in June, on June 4th. And so the situation that we're in is that the public use zoning district is now a part of the Salina zoning ordinance, but there is no physical property within the city that has a public use zoning designation. And so the final implementation step to carry that out would be to actually physically rezone properties within the city limits to the public use designation. At our recommendation, the commission started with school district-owned properties because the list of city-owned property is more diverse and more complicated. And as you're aware, we created various sub-districts of educational facilities, public facilities, and an exposition district. And so the educational facilities sub-district is what would apply to the school district properties. The short answer is that we tried to do too much, too fast, and did it inappropriately. And the city has an organizational value of doing it right and doing the right thing, and we missed on both counts. We didn't do it right, and the right thing to do is to withdraw what's been done to date and initiate new applications so that correct notification and due process procedures are followed from start to finish. And so we've itemized for you some of the items where we failed, and the failure does not lie in any way with USD 305, and the failure does not lie in any way with the Planning Commission, who relied on the information that the planning staff gave them. The failure lies with the planning staff to properly execute the plan for doing this in a orderly fashion that provides all the public notice and explanation that needs to be done. So you had a meeting scheduled on May the 15th. That was advertised based on our best approximation of when we could get all the descriptions and sites put together. The one wild card that threw us off track initially, there was a land swap that was executed over at the Lakewood Middle School between the school district and Mr. Augustine, and we had to confirm that the land ownership transfer had actually occurred, one, and then two, make sure that we properly captured that legal description and had a correct map for the Lakewood Middle School campus. Seeing that occurred, we realized that we couldn't send notice out properly to all property owners within 200 feet of the school sites until June the 5th. So we had a journal notice that advertised a May 15th hearing date. That, because it was advertised in the journal, had to be held, but staff recommended that no action be taken on the application and that the statutory public hearing be held on the 5th. You held that hearing on the 5th. You deferred action to allow the school district to act on that, to review the list and see which ones they would request for rezoning. They submitted a written response based on their June 12th action. You held a public hearing on the 19th. Concerns were expressed on that meeting of the 19th about the notice and lack of sign posting on the various properties. You were ill-advised by planning staff about what the consequences of that was. Subsequent to that hearing, it was reviewed in detail by city staff and the city attorney, and we've itemized there the May 15th and June 5th public hearings were potentially contradictory was one issue, but the primary issue was the failure to post signs on the property, and the poor advice you received on that falls directly to me. So the city attorney has reviewed this. He has issued a legal opinion that even though the sign posting is not required by statute, it is required by our own local zoning code and to properly process any type of zoning case. It is appropriate to comply with both of those, because failure to do so could result in a challenge to the validity of the rezoning action. And then also contained in your report is a summary of the city attorney's legal opinion that every zoning case has a 30-day window in which it can be challenged legally in district court. And that 30-day challenge period is established by the state statute. So the cases of the past where there were rezoning actions where signs were not posted are not in jeopardy as to their validity at all, because there was no legal challenge to the lack of posting of the signs. So that leaves us back to the current case, and in addition to all the things that we itemized for you, again, the 14 sites at once, the 735 pieces of mail. Another thing that we determined was, although we had the correct list of owners, the list of labels that was attached to the South High mailing was a duplicate of the South Middle School. So the people in the proximity of South Middle School got a dual mailing, and nobody within 200 feet of South High had any mailed notice. So for these reasons, our recommendation is the application that you initiated that was filed in April be withdrawn, and that new applications, plural, be initiated for the various school sites, and that the remapping process start over on a new schedule. And while the city attorney has advised that it is not legally prohibited to lump non-contiguous properties into the same application, for one of the areas where staff failed signally was the ability to help Ms. Hernandez formulate a protest petition if that was her desire. And so that right has been, was eliminated in that process and needs to be reinstated. And by applying for these individually, campus by campus, that will make it clear that they are all individual cases that stand on their own and that each can be protested individually. So we have put in your packet a proposed draft of a letter that would go out to the nearby property owners, with one specifically addressed to the South High situation. Upon the further reflection, and we have that blank, the effort to have a blanket letter that would address all the owners will now be substituted with a letter that will be targeted to each individual school, so that there's language in there that says the notice is being sent to owners within 200 feet of the school district property proposed for rezoning in your neighborhood. What will substitute there will be the name of the individual school, and the letter will have the name of the individual school, and there will be an individual case number assigned to each school. So the items that you see there referring to application 12-2A as a substitute for 12-2 will be substituted with an individual case number for each school. Then we have outlined for you a sample of what we do for the notice of public hearing, and we have outlined a schedule for you that if you withdraw the current 12-2 application and initiate a new one, then the actual amended application will be filed on the 31st of August. There will be notice published or sent to the Journal on the 6th of September, Property owner letters will be mailed on the 7th of September. The notice will be published in the Salina Journal. Signs will be posted on the property on the 11th of September, and a new public hearing to hear any public input would be heard on the 2nd of October. This doesn't require any additional action by USD 305 Board of Education. The memo from June 13, 2012 stands in its present form. So procedurally, we blew it, and we have to start over because that's doing the right thing, and it's also obligation to do it right the first time, which we've failed to do. The other information we received was quite a bit of feedback, and I took this in person. I got it in phone calls. Dustin got it in phone calls. There were a remarkable number of people who, when they got the letter, and John, have you shut everything off? Okay. Two items. One is the sample map, and we had one further suggestion from Mr. Kennedy that I think we can make. And then the other thing, John, I wanted you to show, did you capture the photo of the zoning sign?
Yes, we showed that.
Yeah, we saw that. I don't have eyes in the back of my head, so I can't always see what's up there. This is the sign that gets posted on the property. It doesn't get into specifics, but if you see the sign and want to follow up on it, then you can. So that is a sample. I cannot say that the 14 signs that we put on the school district properties may have to be custom made, and they may have to have some additional detail. But we did have a number of people who received the map and were of the belief that the purpose of the circle around the schools was to show areas that the school district was trying to acquire or wanting to acquire. So the letters and the maps have been modified to try to clarify that this has nothing to do with expansion or acquisition, but we have a notification area and we have a request area. Mr. Kennedy suggested that we and to qualify that further by saying school site proposed for rezoning, but on a map, this represents South Middle School. This line represents the notification area, and why that line is important is that in the case of a legal protest petition, only people who reside within that oval are eligible to sign a protest petition. And I wanted to amplify on that just slightly. When we had the case over there in Golden Eagle on Red Hawk, there were people there, and they wanted to circulate a petition. And so I sat down with them and I explained the difference between, there are two types of petitions. One is a petition that just tells the Planning Commission how the neighborhood feels about something, and then there's an actual legal protest petition that is protesting an action or potential action taken by the Planning Commission. And a legal protest petition filed by more than 20% of the owners inside that area, the effect of that is to require that the zoning cannot be changed without a vote of 4 city commissioners. And if you think that that is not significant, I will tell you that in 1982, the City Commission approved an ordinance rezoning the property for the Central Mall 3-2, and the ordinance failed because there was a protest petition filed and there weren't 4 city commissioners who voted for it. So even though a majority of the City Commission favored the mall rezoning, it failed because of the protest petition. So I wanted to clarify for you the difference between a legal protest petition, which occurs after the Planning Commission's rendered a decision, with a petition you may see on any given case where they've circulated a petition around the neighborhood. Might be people 6 blocks away that have an opinion and have signed the petition. that is simply a petition that is an expression of their sentiment. It's not a legal protest petition. So there's two different kinds. But I'd be happy to answer questions about anything that you see in your packet there or in the report. One of the things that you have in your packet is a listing of all the school locations and their present zoning classification, and then companion with that, which is the first compiled list we've ever had since I've worked for the city, which is a compilation of the legal description of every school district site within the city of Salina. And I would point out that missing from that, but in your packet in the form of a survey, is Glennifer Hill School Site, which is the Board of Education offices. And last night, the Salina City Commission accepted the ownership transfer of the lower playground area of the Glennifer Hill School Site for city ownership. The city had been leasing that from the school district for a neighborhood park site, and as of last night, the city of Salina is the owner of that, as well as the spray grounds that are north of the Heritage at Hawthorne, which is part of the former Hawthorne school site. Those two items, or two parcels, the property was transferred to the city of Salina as of last night. So the bottom line is, what we would need in the way of action today would be a motion to formally withdraw the application initiated in April, and to initiate new amended applications, plural, which would include the former Glennifer Hill School Site as far as the Board of Education offices, direct staff to prepare appropriate notices, place signs on the sites in accordance with the attached calendar, with a public hearing date set for October 2nd. And if there's any deviation from that, you are free to do so.
We still have five.
But we still have 5 here. That is a quorum. So 1, we would open up any questions you have of the report or attached materials, or 2, we should hear any public comment about the plan for withdrawal and reinitiation.
One question I have is, so we're going to, if I hear you correctly, we're going to hear this 14 separate times at a meeting. You're going to bring each school in front of us one at a time.
There will be a single public hearing on the 2nd of October, but there will be it will be brought on the agenda individually as 14 sites, and then you'll have a yay or nay on each school site, one by one.
And a public comment session.
And a public comment session for, it will be a single public hearing, but instead of hearing in total and having somebody come to the podium and say, I'm here to speak about Stewart School, it will basically follow the format that you see there. And is anyone here, Central High School will be up. Does anyone have any comments on, in the notification of Central High? So it will be 14 action items on the agenda.
Well, live and learn. I know staff's put a lot of energy and resources into this the first time around, but I just commend you for being thorough, though, and reviewing it, and that, you know, we want to get it right, so we appreciate the further review of it. From the public, is there anyone that would like to comment on this application or withdrawal of application? Yes, come on up. Mrs. Hernandez, isn't it? Yes. Yeah.
Sandra Hernandez at 1940 Starlight Drive. First of all, I too would like to commend the staff in recognizing that the process did have errors, and that they're willing to take a moment and look at that and realize that with them breaking new ground on all of these properties and rezoning them all pretty much at the same time, that, it's good to take it a little bit slower, and I really appreciate it. I appreciate all the hard work that Mr. Andrew has put into it, and I appreciate the future work that is going to be done on this as well. My question, though, to Mr. Andrew is, in this next hearing, when all 14 are going to be addressed, does that mean that there are going to be 14 separate signs on all the properties in that same time frame?
There will be one, we'll take a look at some of them. I think, even though it's not necessarily mandatory, it's sign placement, but I think if you're looking at a central high that's bounded on streets on 4 sides, we may look at posting 4 signs at Central High to make sure that we capture that. But that is one of the challenges when you're looking at a piece of property and you're posting a sign. You want to put it in a location where it's most likely to be seen by people who do not physically receive a letter. So we're open to any thoughts that you have in that regard, but if you're looking at Glenifer Hill, for instance, if you put a sign on gypsum, you might not capture people who drive up and down Stapler. Or if you choose Crawford at Central High, you may miss everybody on McAdams. So we're open to thoughts on that. The thought generally would be that each school site would have a well-placed sign on the property, but we realize that we're dealing with some fairly large properties like Central High, which is 30 acres, and so we would be open to whatever we think or you think would provide the best notice.
I appreciate that. The other question I have is that in relation to the signs, they're going to generate a lot of questions. Now, I know earlier you spoke that in the prior process that you did receive phone calls and you were taking those in your office. How are those calls or questions going to be tracked within the staff office?
Well, what I generally do when we send a notice out is we tell people that they may correspond back with us by letter, by email, or by phone call. And if I get a phone call from someone that says they are unable to attend the public hearing, but they have a concern or question about X, then I write their name and address down, and when it comes to the public hearing, the planning commissioners either have at their place a printed email, a letter, or during the public comment period that happens more often with the Board of Zoning Appeals than it does the Planning Commission, we would report to the commission that we had a phone call from so-and-so who was unable to attend the hearing, but they are opposed to the request. That's the way we generally handle it. But in terms of somebody calls and they say, I had a gentleman named Mr. Brown whose ancestors had previously owned the site of Central High, and they said, our family's already lost property to the school district. We don't want to lose any more. Why is the school district trying to acquire more property around Central High? I explained to them that they were not trying to acquire more property, that represented the area that people receive mail notice, and he said, well, if they're not going to expand, then I'm not concerned, and that was the end of it. So I consider that to be resolved. If we receive an email, then we print them out and we either include them in the packet or we will assemble them and put them up at their places. The commissioners today have a letter from Mr. Sanderson on the hospice case, and they have a letter from Doug Hill about the Kansas Wesleyan sign, and those letters are up at their place there, so they'll see them.
Okay, and then the last thing is just, I want to clarify that during this time frame of when you're posting these signs are going to all be up at the same time. Is that correct?
Yes, some of them may go up early, but the signs have to be posted on that, by that day, and that day is September 11th. So the statute requires that the journal notice be published, that people have letters in hand, and that signs be posted at least 20 days before the hearing is held so that people have time to ask questions, prepare for the hearing, get clarifications. But it has to be done by September 11th. If for efficiency reasons we do it on the 7th or 8th or whatever, that's okay, but we can't do it on the 15th. It has to be by the 11th.
Thank you, sir. And I'd like to thank the commission, too, for considering stopping this process and withdrawing Z12-2 and moving forward with the new process that has started on and being more effective in it. And I would just like to thank you for your time, and I'd like to thank Mr. Andrew for his time as well. Thank you.
I do have a question for you, though.
Absolutely.
And Dean had asked you, since you seem to be concerned about the sign, and he asked, where would you recommend it? I mean, I don't want to come back later on and say, I cannot believe that you put a sign down on the corner of whatever that, I mean, where would you recommend this sign, since you're so concerned about the sign? So where would they be best put that you feel 100% comfortable that everybody's going to see the sign?
Well, first of all, I'd like to clarify that I'm not just concerned about the sign. The sign is a big part of the process, and I learned that in following the process. I trust that the staff, now being aware of some of the procedural errors that had taken place, I do trust the staff to place those signs in the best representative place that the community is going to see. And I feel confident that they're going to do that because I had no idea that they would even consider the possibility of 4 signs for Central High. So I would not begin to want to tell the staff where to place those signs. I have full confidence in them that they will place them in the right place.
So you're okay that if city staff places one sign on property of what's being rezoned, no matter where they put it, you're okay with where they place that sign? That you will not be, I mean, because I feel like you're really opposed to that, and what I don't want to do is have you come back later and say, I can't believe on Meadowlark, the sign was down on the corner of whatever, I asked 22 neighbors and nobody saw it. Do you want this, I mean, I don't want that to be another problem again.
No, I understand that, and I guess if I had to be specific about it, I would say you want to place it at a point to where it's going to get most of the public's view.
Okay.
And if that is at the front of the school, because there's a lot of pedestrian traffic going in and out of school, then that's where they would place it.
Is there a law that says that the sign has to be placed just on the property, is that correct?
Just physically on the property that's proposed for rezoning.
Okay. And so that's all I was making clear, was he was asking you for help and saying if you had any interest in that.
When we have large sites, we can always go over and above, but we don't want to not achieve expectations. So these are probably going to be custom-made signs, and so they should be able to be mass-produced, and if we have people out placing signs, it shouldn't make a great deal of difference whether we do 1 at Central High or 4, but we'll just try to exercise our best judgment so that we capture the most traffic and the most visibility.
Thank you.
Thank you.
Thank you.
Is there anyone else from the public that would like to comment on this item? If there's none, I'll close the public session. We'll bring it back to the commission. Gentlemen, is there a motion on this?
Basically, we have scripted it out there that there be a motion to withdraw application Z12-2, initiate new amended rezoning applications, including the former Glennifer Hill School, direct staff to prepare appropriate notices place signs on all 14 sites in accordance with the attached calendar, with a public hearing date on the new applications on October 2nd, 2012.
That is the first paragraph under recommended action. Is there anybody who'd like to make that motion?
I would make that motion.
Is there a second?
Second.
All in favor, say aye.
Aye.
Any opposed? Item number 7, other matters.
Under other matters, we do not have anything specifically scheduled for the commission for the day after Labor Day, which might be a well-deserved holiday, but I would ask you one thing. Do you think you have enough understanding of what your recommendation was and what we're going to do to the university district to consist of your recommendation, or would you like to see that in a final text form before you make a recommendation, or do you feel comfortable that you have given us the outlines of what the amendment would consist of, which is basically exceptions for the advertising signs?
Yeah, you had 2 motions for that, and I think
Right.
the only one that you lacked was a 3rd motion for the...
And in the case of the electronic changeable copy signs, we would draft something up, give it to Kansas Wesleyan, and we'd bring that back for separate consideration.
And wouldn't that give you a chance to review the more of that whole?
So as it stands at this point in time, I would anticipate we would not have a meeting on the day after Labor Day, but we will meet on the 18th of September.
You're just trying to make us feel good for being here for, is this a record length meeting?
I don't know, I'm afraid to look at the clock.
I think we have 8 o'clock.
If we are concluded with the business, I will
Crystal
adjourn the meeting. And thank you all for your patience and your time. And Crystal, I don't envy you to have to type the minutes out.